For matter, end of the list, the connected matter is posted today at serial number 16, my lord. Today. And
Government ಮುಂಚೆನೇ ಹೇಳ್ಬಿಟ್ಟು.
yes, ma'am, I'll serve the court.
Expected divorce has been granted. Family.
2016 matter, my lord, family court matter.
What is date?
Come on.
Submission. Lord, in writ appeal wherein Khata Lordship had passed an order to file objection regarding Khata entries of Khata, my lord. A positive direction was issued. In that case, my lord, Lordship had passed an order that the matter was. I want to seek for clarification of that order, my lord, because I have been directed to appear before the single judge on 14th. Because my main contention also positive direction could not be issued because my only submission was
That is a clarification.
my lord, it should before the single judge, my stand was, my lord, if given an opportunity in accordance with law, order will be passed. If that can be on 13th, my lord,
On
13th.
10th will have.
10th, sorry, my lord, I should 10th to 12, I am going to Kum, my lord, that's why. 13th. Otherwise, my colleague will appear, my lord, if lordship permits.
No.
That's why my presence should be there. That's why I'm seeking for 13th.
30.
Please.
My lord, criminal appeal, they are convicted under section POCSO Act, is in judicial custody since 8 years, more than 8 years. I'm filing final hearings again.
Okay. Noted. From length of conviction.
My lord, one more submission. Today, the final hearing, serial number 34, my lord. They are convicted under section 377 and IPC and POCSO Act section 6. They are in judicial custody since 8 years, 6 months. I'm not going to argue on the.
Juvenile case. ನಾಳೆ ಹೇಳ್ಕೊಡ್ಲ
We'll take up today.
My lord, my only submission, I'm not going to argue on the merits of the case.
Take up the matter.
Point.
Afternoon. Yes.
Yes, yes.
We'll take up. You must be ready 360 degrees.
I'm
Irrespective of your stand. We want to make up our mind only after hearing. No question of conceding unless that discretion is left to us. Be ready. Be ready.
Yes, my lord.
Convicted for life.
Life, my
For
lord.
offense POCSO.
POCSO and
Yes, you have to argue that he is not you attained majority at that point of time. POCSO does not attract. That point you have to convince us.
yes, my lord. I will convince. my lord.
Otherwise, how we can reduce the sentence? You have to argue on merit.
I will argue.
Yes, to argue on merit. See.
My lord, hearing an IFR suspension sentence and bail.
Good.
The appellant is in JC since 7 years.
Good.
My lords, in this matter, your lordship had, the previous bench had directed the trial court to inquire on the question of juvenility of it. A report probably must have come. 6 weeks time was granted. So now more than 6 weeks have passed. I have inquired with the registry. The report is here. This for any date may kindly be fixed. in this matter. I'm very grateful to Lordship.
Page wise judges. Till number 17 to 19. Page number 30, till number 20.
Serial number 20. Serial number 20, my lord.
20?
Serial number 20. ಅದ್ರೊಳಗ citation ಏನದ ಡಿಪೆಂಡೆನ್ಸಿ ಮೇಲೆ ಸ್ವಲ್ಪ ಕಲೆಕ್ಟ್ ಮಾಡೋದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ನಾಗ
He lists the matter at request on.
2 weeks time.
Hello, when do you want? Huh? When do you want?
2 weeks time.
ಏನಕ್ಕೆ ರಿಸರ್ಚ್ ಮಾಡಿ 2 ವಾರ ಬೇಕಾ?
Loss of dependence.
ಲೈವ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಲೈವ್ ಲಾ ಇಂಡಿಯನ್ ಕಾನೂನ್ ಗೂಗಲ್ I'm just saying don't make it so tedious, make use of these IA tools, right? Next week date next week date
Next.
MF MVC ಅಲ್ಲಿ ಏನ್ ರಿಸರ್ಚ್ ಸುಮ್ನೆ ಇಂಡಿಯನ್ ಕಾನೂನ್ ಗೂಗಲ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರುತ್ತೆ ಅಷ್ಟೇ.
Next.
ಹಾ
Page number 31, till number 21 to 24.
Serial number 23, my lords, I have proxy counsel appearing on behalf of appellant, my lords. 23,
at
a week's
request-
accommodation.
at request we list on date.
Please, my lords, oblige.
Page number 32, till number 25 to 29. Page number 33, 30 to 33. Page number 34, 34 to 36, 35, 37 to 41, 36, 42, 37, 40. Orders matter till number 1, Manvendra Reddy.
I appear for the appellant in this matter, my lords. I am filing an
Yes,
I am filing an application for publication of paper for IA for publishing notice for respondents, my lords. Because 3 times notice have been,
3 times ಆಗಿದ್ಯಾ?
yes, it has been returned as unserved.
Three times ಆಗಿದ್ಯಾ?
3 times agide, my lords. I have written that in the affidavit also.
Your
my lords.
state.
Yes, my lords, I have said in the
Counsel
affidavit.
for the appellant submits that notice has been issued on 3 occasions and the respondents unserved response evading service of summons deliberately. Full stop. Taking note of the government's made notice in so far as unserved respondents 8 to 12 and respondent 14 to 15 is permitted to be effected by way of substituted service
Please.
by publication of notice in Kannada Daily Vijayvani as well as
Vijaypur edition. my lords.
Vijayvani. A publication to be carried out on or before so and so, showing the date of hearing as so and so. Accordingly, I is allowed.
Please, oblige me.
Till number 2, Subhash Malapur.
ಏನ್ ಹೇಳಿರಿ?
For Subhash Mallapur, a week's time for compliance.
Weeks time granted. For what is the main matter?
Mallapur is appearing. accepting the tender who is not having the license for supplying the food to the animals in the zoo. For that reason, my lord, enquiry was issued. That is challenged before the KAT.
Which time granted? Which time? 2 days time, sir. What on merits, what is the position? Can you pass on? Taken tomorrow. I have. Each time granted for necessary compliance.
Additional HPP,
Reference matter minutes.
Vishal Pratap is there, no?
Yes,
He's for the accused, huh?
Ah.
So his appeal also there.
yes, ma'am.
Why this appeal listed? Why is it listed today?
It's coming regularly, my
1
lords.
of 24.
Yes,
Suspension
yes.
of sentence is there.
Come here, come here, come. Come.
I not filed
Huh?
objection. I not filed objection, short accommodation.
This is the only matter, madam. RC matter only it is, huh?
Connected matter. Next week reckoning. How does it happen in English? Regular matter. My lords.
For hearing. Yes.
My lords.
What about this one application? You will post this matter for hearing. Are you ready?
I am ready, my lords. There is one more reference, death penalty case, which is posted for final hearing also today.
Number 3 alwa, same others. 3 and 3.1.
3.1 and 3, both.
Your appeal is 3.1
I am appearing for 3.1 and also respondent for the reference.
reference, yes. So what about IA number 1?
IA number 1, we have filed, my lords, seeking suspension of sentence.
Hmm.
My lords, in this case, all the women who were accused were on bail at the time during the course of trial.
Hmm.
And if you see the merits of the case also, very briefly, my lords, the case of the prosecution, which is at page 33, para 31, may I take your lordship to that? Para 31, which is on page 33, very briefly.
37, another appeal is pending in respect of this incident.
Not this incident. That's a different case.
That's different.
So here, your lordship may kindly come to page 33 of my main petition.
Hmm.
I am referring to the case of the prosecution itself. what the learned judge has
Hmm. You are
said.
the own brother of the deceased. You are own brother of the deceased.
Brother of the deceased.
Huh. Hmm.
Well, it's on 3/6/2017 at about 3:30 p.m.
Hmm.
Complainant, his wife, Banu Begum and his mother were sitting in the room of the school where parents of the complainant were living. And these all the people, my lords, and others came to the complainant with an intention to kill the complainant and his wife Banu by holding club, stone and kerosene. In that, Ibrahim Saab, Muhammad Saab Attar, by abusing complainant that you bastards, Sabya, you being bastard Beda, you want my sister, by abusing assaulted the complainant on his head with stone, which Ibrahim Saab was holding. Complainant's mother ran outside from the room to call the people. Akbar hit the complainant with a club on his back. Ibrahim caught hold and bite on the left shoulder of the complainant. Complainant and his wife, being afraid, went to the house where the complainant and his wife were usually residing. Jilan and Ibrahim, both of them poured kerosene and lit the fire to the house. Now, hence, complainant and his wife came out under fear. Complainant's wife, Banu Begum, was caught hold by Ramzan B, Attar B, Azma Dhakni, and dragged her towards the house. At that time,
Just a minute, just tell us, PW1 is the eyewitness of the incident.
PW1, there are 12 eyewitnesses, in fact.
He is the injured eyewitness.
Yes, and PW1 is the injured eyewitness.
This is his wife.
This is his wife. But incidentally, my lords,
Incident of honor killing.
Yes.
incident of honor killing, that is what prosecutions projected. Now, my lords, out of 12 eyewitnesses in this case, PW 3, 8, 11, 12, 14, 15, 16, 17, 18, 19, 20, and 21, my lords, these are the eyewitnesses. Out of these, 12, 14, 15, 16, 17, 18, 19, and 20 did not support the case of prosecution. These are independent witnesses. And those who have supported are only 4 witnesses. And these 4 witnesses are 8, 10, 11, and 21. 8 is the mother of the complainant. 10 is sister of the complainant. And 11 is the husband of PW10, again a close relative. And 21 is the cousin of the complainant. And the entire neighborhood where, so the entire case is based on the testimony of interested witnesses who have the outcome. And there is also a counter case saying
That any bar to.
there is no bar, but my lords, it has to be taken with extreme caution, because the caution is important in this case, because independent witnesses have not supported the case of prosecution. And-
A honor killing of 21 years, girl, she was
She was pregnant. She was
Pregnant by
pregnant.
that.
Oh,
Yes,
she was
yes.
pregnant at that
Yes.
point.
She was pregnant at the time. So I am only bringing some facts. And but insofar as those appeal is concerned, the other accused, the woman, their role is not there. The death is because of the pouring of kerosene. So those other appellants, my lord, that can be taken a different view.
Which one?
The appeal, connected appeal, PW, let's accused number 4, 5, 6, 7. The 6, 7, my lords, and 8. Now the allegation of pouring kerosene and burning is on accused number 1 and 2. And accused number 3 is a juvenile. The rest of them are women folks, and they don't even live there. In order to implicate them, they brought the direct allegation of the causing the incident of pouring and killing her is on accused number 1 and 2, and they are the one who are awarded death penalty. I will be arguing why it is not rarest of rare case. If your lordship will give me some room, and I'll be arguing for acquittal for these people.
You argue, will take up for final hearing.
Final
not
hearing,
for
Ken.
IA, Not
Yes.
for this interim
And-
application.
Any date your lordship is convenient, we'll fix that date. On that, I'll argue the matter.
So now what about IA?
IA, my lords, if your lordship can dispose the IA at that time itself, final hearing, all IA also stands disposed. Once.
What about that juvenile, this one?
The juvenile case is still going on before the Juvenile Justice Board, and learned SPP was also directed to present the papers concerning the juvenile. So he must have presented, I'm not aware of it.
Let the case.
And anyways, that being,
For the juvenile
that is
court.
seized by that
Yes.
court.
Yes, yes. Now, just remove it. That's that. Have a date. Now, what about the juvenile, whether he is on bail or not?
Juvenile is on bail.
He's on bail.
He's on.
He's on bail.
He's released because and he is the one who is taking care of the children.
For how long it is pending before this one, juvenile court?
It's It's, my lords, I am not aware, my lords, but
Incident
state
is of the year 2017.
17,
Ah.
yes, it is pending for quite some time now. Yes,
9 years, for 9 years,
Yes.
last 9 years,
past 9 is,
pending.
Yes.
so some direction may be passed from this court to complete the,
Where is the papers? You place some paper for this one. Yes,
Next.
you place the proceedings copy, at least order sheet.
my lord, that juvenile, my lord, see, I don't know, I am trying to reach him to get the papers. There is a direction to the SPP to get the papers. And he has the power also to get it.
Even defense can do it. Because he is arguing
Allah,
on
he
behalf
is
of-
power
he is
is-
taking advantage of him.
ಅಲ್ಲ, ನಾನು ಅಲ್ಲಿ ಕೆಳಗೆ
So what?
prosecution is filed there, this is juvenile.
It's no problem.
What is the number, case number? Juvenile.
Exactly,
case
I
number. You
don't,
don't have.
I am not aware, my lords.
What is his name, Mr.?
His name, my lord.
Juvenile.
The Ju-
Juvenile name?
the use numbers.
What is his name at least?
I'm getting the name, my lords.
Accused number, at least accused.
Accused number 3, my lords.
Accused number. In the course of arguing the.
Imam Saab, son of
Yes.
Muhammad Saab.
Better. Learn counsel for the appellant. While arguing on IA 1 of 2000, IA 1 of 2000.
IA 1 of 2020, 24 minutes.
Brought to the knowledge of this court that the juvenile involved in this case, juvenile involved in this case, the case against him is still under, he is still facing trial.
Trial.
Before the juvenile.
Before the
court.
Juvenile Justice Board.
Juvenile Justice Board, JJ Board. The incident on perusal of records, it seems that the incident is of the year 2017 and as such, the deputy director, deputy secretary of Juvenile Justice Board, Juvenile Justice Committee is directed to submit a report in respect of the stage of the proceedings. In crime number,
In crime number minutes,
crime number ಹೇಳಿ. In crime number,
in crime in minutes.
he's appointed as intervener. Yeah, in the capacity of intervener. In crime
In
number.
crime number 14 of 2017.
Number
14 of 2017.
2017, in the capacity of intervener.
Registered by Talikoti Police Station.
Registered
By
by
Talikoti Police Station.
Talikoti Police Station. Crime number, Talikoti Police Station. On the capacity of intervener. By next date is date on or before so and so date haaki. The copy of this order shall made available to the concerned
Please.
immediately, forthwith.
Yes, madam. And
Hmm.
on previous occasion, when this matter had come up, your lordship, sitting with Lord Justice Huder, had directed some documents to be filed with regard to the socio-economic condition of these people. Accused number 1 and 2, there in terms of those guidelines which was issued by this court, when looking into whether death penalty is ideal or not.
Here,
That means
see.
There was direction.
that Manoj is.
Yes.
That means.
So this appeal on 13-2.
I'm grateful to your lordship. Please.
In the meantime, the learned additional SPP is permitted to file objection if any to IA number 1 of 24.
Please.
The process for the
You just go through all those judgments, including that Machi Singh, Shraddhananda, all those judgments. Mister,
My lords,
huh?
yes, my lords, on death penalty.
Yes, that penalty.
That, yes, on that also. And my lords, there is on serial number 37, there is one more criminal reference case, and I have also filed.
Hmm.
Any date may be fixed, that one also we will argue on merits. That's also a reference case.
Huh?
Yes.
It's
And
not
I
in
am
the-
also ready for
The list, yes, yes. Remain in the list.
re-election. amendment. I am very grateful to you, Lord.
Yes.
Number 4, Hitesh Padiga.
I appear for the complainant.
Number 4,
I appear for the complainant.
My lord, in this matter, my lord, on the last date of hearing, my friend has filed the memo along with the GO issued by the government for filing the SLP. What is the status of SLP, my lord?
They have filed that
ascertain
Geo already 1.5 months back,
December.
December. It's almost 1.5 months.
My lord, the other ದಿವಸ I ascertain, my lord.
Monday, but not, no further time will be given.
Please, my
We list on 10th. Make clear that status of proposed filing of SLP to placed on record and no further time would be granted for the respondents.
Obliged.
List on Monday in the same state.
Please.
Next.
Oh, my lord, I'm appearing for R2. I am appearing for R2, my lord. I file application for recalling.
What about the R2?
Yes, sir, I am appearing. I am filing application for recalling.
Recall, you have to file application.
Affidavit.
Yes.
Ah.
Yes, we'll recall, let him talk. Yes,
Ah,
you
let-
please produce.
Ah,
For my response, a week's time maybe.
ಅದು ಮುಗಿಲಿ, then.
ಅದೇ
Also.
another is
ನಿಮ್ದೇನು
submission. Serial number 4, your lordship posted it on 10th minute, it will be taken up on 11th minutes.
11.
Please, oblige.
Mahesh Patil,
My lord, in this case, on last date of hearing, lordship had asked to what has happened to the learned single judge given a direction to redo the entire list. The list has been redone, my lord, and this is the communication order, final order passed. I'm furnishing, along with the memo, I'll furnish, my lord, now. In that, only 2 candidates have been edited. Only 2 persons have been found that they are not eligible, my lord.
Just tell us what are the facts?
My lord, at page number 31, this honorable, the learned single judges, they had challenged the appointments of some of the candidates. On the ground, my lord, the notification was called for only English medium students, my lord. Their allegation was some of the candidates have passed Kannada medium and they have been appointed. That was challenged before this honorable court. This honorable court, my lord, made certain observation and gave a direction to the respondent number 2 and 3 to look into the observations made and verify whether actually
They
they
have
are
done Kannada medium or?
or English medium. We have issued, sought inquiry from all the universities, my lord. They have given a genuineness that they have passed in English medium, my lord. On last occasion, lordship had said if such order is passed, they have to challenge separately.
Separate.
Yes, my lord. That's what order is already passed on 26/3/2024 itself. Only 2 candidates have been found ineligible, my lord, and they
So have a look at it.
Yes, my lord, I have seen. And my lord, here, admittedly, my lord, the candidates, my lord, who have, my lord, studied in, my lord, the English, for those, my lord, these notifications were called. And my lord, and
They are ineligible.
yes, my lord, and several of, my lord, several of the candidates, my lord, who are, my lord, Kannada medium, including the petitioners herein, had applied for that post, my lord. And my lord, the petitioners herein, my lord, they were, my lord, they had secured more marks undoubtedly, and my lord, they were more meritorious. And my lord, all other, my lord, junior candidates, my lord, who, my lord, studied in, my lord, Kannada medium, their, my lord, candidature was considered and they were given appointment orders. And my lord, I had, my lord, we had challenged, my lord, that before the learned single judge, my lord, and it was held, my lord. I admittedly, my lord, there can be no negative equality, that apart. Now, my lord, the learned single judge, my lord, had, my lord, made an observations, my lord, which is at page.
No, correct. So what does it say?
My lord, they say, my lord, as to, since, my lord, the notification provides, my lord, only for the instructions only in English medium, it has to be English medium only, and no candidates of Kannada medium should be, my lord, entertained. Yes, my lord. But now, my lord, the several of the candidates, my lord, we have made response also. And, my lord, we have produced those documents saying as to, my lord, they have studied in Kannada medium, and it is the, my lord, the certificates are very much, my lord, made as a part of record. And, my lord, looking into those certificates, my lord, there was a, my lord, observation and directions, my lord, to the respondents to, my lord, to look into those and review the entire. Now, my lord, now what had happened? Now, my lord, they have produced, my lord, this, my lord, the communication to the KPSC. This cannot be, my lord, said to have, this cannot be in compliance with regard to, my lord, the observations made by the learned single judge, my lord, because learned single judge had directed, my lord, to review. This is not review, my lord. They have, my lord, simply, my lord, they have secured.
No, those people are arrayed here, is it?
Yes, those people have been arrayed as, my lord, the respondents.
Let us see. We'll ask them here, demonstrate independently also.
Yes, my lord.
Hmm.
And here, my lord, there are 2 matters, my lord. In the connected matter, my lord.
So one by one we'll go. Now, the private respondents at respondent number 4 to 9. 4 to 9.
Yes,
to demonstrate whether they have done which, what is the qualification?
in Kannada medium.
Which one? 10th, 12th or which?
No, degree.
Yeah.
Lordship, may I kindly see, my lord, page,
Notification page?
please.
notification, my lord, page
49.
49. And there, my lord, lordship may kindly see,
Just point out to that requirement.
page 53.
ಇಲ್ಲ 49 last paragraph.
Page, my lord, this is
Last paragraph.
49, last paragraph is the, my lord, the
ವಸತಿ
ವಸತಿ ಶಾಲೆಗಳಲ್ಲಿ ಆಂಗ್ಲ ಮಾಧ್ಯಮದಲ್ಲಿ ನಡೆಸುತ್ತಿರುವುದರಿಂದ ಕ್ರಮ ಸಂಖ್ಯೆ 1.
English.
Yes.
Using Kannada.
Yes, my lord, English.
They must have done their degree graduation course in English.
Yes. In English.
That is the requirement.
That is the requirement.
Now you are saying the private respondents are not fulfilled, isn't it?
Not fulfilled and they have studied in Kannada medium.
Correct. So we'll ask.
Even first of all, the petitioner is also not an eligible
I
candidate
have to agree.
because he is also Kannada medium.
My concern, my lord, is, my concern,
Okay, let us see.
Please.
Let us see, just wait.
One observation. Page number 25.
my lord, may-
See,
25, my lord.
Huh.
Para number 11. Undoubtedly, the petitioners have studied degree in the Kannada, in the medium of Kannada, and therefore the petitioners have no legal right to claim appointment as the same is contrary to the notification. The, my lord, this has been, my lord, admitted by the petitioners also, they have studied in Kannada medium and they have no legal right, my lord.
you are
My lord,
right.
and the only issue is that, my lord, it is his allegation that, my lord, some of the Kannada medium students, they have been appointed.
Correct.
After the direction, it should be the learner single judge, my lord. Entire thing have been reviewed and, my lord, the.
Correct, so.
Lord,
that's-
yes.
but may I, may,
Just, now, we'll settle the issue at rest.
please, please.
There's nothing to hide. If you have done in Kannada medium and you fulfill it with affidavit, your credential copy, you produce it. We'll take note of it and we'll see what is to be done. We won't convert this into a PIL. He has no locus standi prima facie. Before we bring it to a logical end, otherwise again, one more round of litigation.
Yes.
Over warrant.
Yes.
So let us see, you, prima facie you satisfy. That's.
Private
I
respondent.
have respondent 4, 6, 7, 8 here. My lordship, in this, the college itself has clarified that I have passed my degree English medium.
You file affidavit and you take your stand. That's.
Please,
Have a
Mr.
look at it and then
Please,
we'll see
please.
what is to be done.
Please.
Counsel for the petitioners has made a assertion that respondents 4 to 9 don't fulfill the criteria of completing the graduation course in English medium as they have studied in Kannada medium. Full stop. Learned AGA has filed along with memo. a
Lord,
report.
respond number 2, 3.
Respond number 3.
2. my lord.
2 has filed a memo along with the report dated 26/3/2024 stating that they have looked into the direction of the learned single judge as regards the medium of instruction in which the qualifying degree was obtained by the private respondent. Full stop. However, before any finality, any adjudication is made as regards the said contention, which appears to be the only contention left out, the respondents 4 to 9 to file affidavits and place their credentials of having completed their graduation course in Kannada medium.
In English medium. English.
In English medium by the next date. Relist the matter on.
My lord,
In connected matter, they are not paid
my lord,
process.
my
till
lord,
date.
in,
In
my lord,
connected matter, they are not yet paid process. till
no,
date,
no,
but this.
the third time, my lord, it is not served, my lord, to the respond number 5 in the connected matter.
6.2, this is in 6.
Yes, my lord. Thanks.
6.
My lord, one more,
6.1, office to put up report regarding notice issued to R6 and R7. Fresh notice process to be taken as regards R5. Now R5 is working with whom?
Lord, with Christ only, my lord, with the Karnataka Residential Education Institutions.
Notice
Society
to
only.
be issued to R5 through respondent number 2.
2, my lord. I will.
Office to hand over copy of hand summons forthwith.
Please.
my lord, one submission, one
Yes,
submission.
yes.
Now, my lord, what had happened? My lord, they could have stopped there. Now, my lord, I have documents to show that, my lord, now they have, my lord, they are operating, my lord, the additional list. Additional, my lord, the list. My lord, in that also, my lord, I am told, my lord, that there are, my lord, the paucity of, my lord, the candidates, my lord.
That will
In for that also, my lord, they are providing, my lord, Canada.
put a full stop to this. You
Please.
file an affidavit.
Please.
Now, whether you get candidates or not, if a recruitment notification says something, you have to adhere to it.
Yes, we have
You
to
file an
adhere to it.
affidavit to that.
Please.
Yes. relist on. Yes, next.
Mr. Savek,
ಯಾವ ಡೇಟ್ ಮೇಡಮ್?
Mahesh,
ಯಾವತ್ತು?
Nayak,
This objection, my lord. With regard to note, my lord, that has been shown below the cost title.
Huh?
Below the cost title, my lord, note is made. Reporting, my lord, defendant number 1A, Shehzadi B. And defendant number 6, Razia B. Died during the pendency of the suit itself, my lord. And so for respondent number 6 is concerned, my lord, seeking.
As far as note 2, you file an affidavit. Insofar as note 2, you file an affidavit.
No, sir. They died in the trial court itself, my lord.
File an affidavit. to
Please.
the, Learned counsel.
And moreover, I have produced amended copy of the plaint, my lord. Amended copy of the plaint. And wherein your lordship will find, my lord, so for respondent number, defendant number 6 is concerned, amendment is already done before the trial court.
Page.
Page, my lord, after Wakalat, I have produced a copy of the plaint, my lord. Sorry, it is not numbered, I think. After Wakalat Nama, sir, copy of plaint, Tiddapadi, second page, your lordship can come. Serial number 6, my lord, item. Already it is reported. And so for the alarms of 1D is concerned, they are already on record.
No. ಏನ್ ತಿದ್ದುಪಡಿ ಆಗಿದೆ?
My lord, with regard to the name of respondent number 6, my lord. Defendant number 6. She died, my lord, accordingly her name is rounded off.
ಅದೇನ್
Page number 2, sir, copy of the plaint. ಕೋರ್ಟ್ ಆದೇಶ ಪ್ರಕಾರ ತಿದ್ದುಪಡಿ ಮಾಡಲಾಗಿದೆ. ಏನು ಆದೇಶ ಏನು ತಿದ್ದುಪಡಿ? ಅದು since this died issueless, my lord.
Correct.
Her name is deleted.
That's not coming out, at least from the order sheet.
I will file affidavit.
ಅಲ್ವಾ? You place that order sheet at least.
Please, sir.
It says ತಿದ್ದುಪಡಿ ಪ್ರಕಾರ. ಅದೇನ್ ತಿದ್ದುಪಡಿ?
Please, my lord, I please.
ಅದೇ ಅಂದ್ರೆ ಅದೇ ಏನ್ ಅದೇ?
I agree. My lord, the urgency is.
Insofar as note number 2, as regards respondent number, defendant number 6 before the trial court, the appellant to file affidavit regarding the explanation made. Okay, now note number 1.
1A, my lord, defendant number 1A is died and her LRs are already on record, my lord.
In light of submission regarding defendant number 1A having died during the pendency of the suit proceedings and LRs already being on record with respect as defendant 1B to 1H, said office objection is overruled in light of the submission made. However, such order is would remain order passed before appearance of the respondents and is subject to modification if facts are so made out upon appearance of the parties. Now notice must go.
My lord, a notice must go, my lord. My request is, my lord, suit for partition and separate petition is filed. I have produced, my lord, family genealogy at 21A, my lord, page number. Parties are governed by Mohammedan law. Khadar Sahib was the proposed, my lord. He had 2 wives, that is Tole B and Tony B and Rajia B. My lord, that Rajia B, my lord, she died issueless. Only from first wedlock, my lord, 2 daughters and 1 son. So, my lord, daughters being the sharers, my lord, for 1/3 share each, because he will get 2/3 and the daughters are concerned, they are 1/3, my lord. So they file simple suit for partition in respect to 2 agricultural properties, my lord. And defendant has set up the contention that already partition is taken place. I request your lordship to come page number 29, my lord.
No, correct, sir. No, what is the interim relief we are seeking?
Interim relief not to alienate and encumber the suit properties, my lord. Your lordship can see the.
We'll say not to alienate.
No.
A1 of 25 has been filed, seeking an order of temporary injunction. Counsel for the appellant has raised various contentions to the effect that the trial court has come to a wrong conclusion. Now, on what basis you are saying the finding is wrong?
Finding, my lord, I request your lordship to come to page number 29, my lord, issues.
Page
29, sir. First issue is, my lord, that burden is upon me, whether the plaintiff proves that themselves and defendants are tenants in common for the suit shall property. That is answered in negative. So for second point is concerned, my lord, whether the defendants prove that during the lifetime of the late father, an oral partition was effected as stated in the written statement. This is answered negative. When it is answered in negative, my lord, am I entitled for my share?
In light of the contentions raised, including that the trial court having recorded a finding that there was no previous partition or to have decreed the suit, the pending further consideration, the respondents are restrained from alienating the property, scheduled property. Issue notice, PCR to be summoned forthwith.
Oblige.
Number 8, KM Thate.
In this case, I undertake to file wakalat for respondent number
Respondent has to comply with the direction of the Lord Single Judge.
3 and 4, my lord. I undertake to file wakalat
So
for
undertakes to file wakalat for respondent
3 and 4.
3 and 4. What is the direction?
Direction, my lord,
To file an objection.
My lord, so far, yes,
I gave a representation
Sure,
that the
sir.
respondents 3 and 4, they have made illegal construction.
Consider representation. Illegal construction by. 3
Yes,
and 4.
respondents 3 and 4.
Hmm.
I made a representation, that representation was required to be considered by the respondent number 2 by passing order under section 187 of the Karnataka Municipalities Act. So that is not being done. So I was before the learned single judge. That direction is also
Just 1 minute. So who appears, authorities chief.
I
town municipal-
appears.
respondent number 2, my lord.
Chief officer.
Please, my lord.
Hmm.
He requests to pass some orders.
Yes.
Please, my lord, I have not received instruction to 4 days time may be granted.
Tomorrow.
ಅಲ್ಲ ನಾನು 2-3 ದಿವಸ ಇರ್ಲಿಲ್ಲ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದೆ
No,
ಟುಡೇ
correct.
ಪ್ಲೀಸ್
Building will come up.
ಪ್ಲೀಸ್
Now,
ಬಿಲ್ಡಿಂಗ್
No, my lord.
ಇಟ್ ಇಸ್ ಓಲ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ಇಟ್ ಇಸ್
Since
ಆಲ್ರೆಡಿ
from 2019, I am moving before the authorities. Nobody is
Not a
taking
new
care of the
construction, my
complaints,
lord.
my lord.
ನಾಟ್ ಎ
Because of that, there are criminal cases are
Have it on
registered
Monday,
between the
take it.
parties.
ಪ್ಲೀಸ್
take it in
ಪ್ಲೀಸ್
writing.
ಪ್ಲೀಸ್
Learned counsel appearing for second respondent.
ಇಲ್ಲ
Submit
ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್
Fourth respondents. Submits.
ಇಲ್ಲಿ
this-
no,
ಇಲ್ಲ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್
second
ಸೆಕೆಂಡ್
one.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್ ಸೆಕೆಂಡ್
second,
ರೆಸ್ಪಾಂಡೆಂಟ್
second accused. respondent. Relist on 10th.
ಗ್ರೇಟ್ ಟೆನ್
Yes, next.
December
Yes.
Number 9. Officers raise objection with regard to difference in signature, the verifying affidavit and wakalat.
Weeks time granted for necessary compliance.
In the meanwhile, my lord, if notice could be ordered for not in, again, as a non-compliance, there is a specific direction
Non-compliance regarding
regarding, my lord, the order passed by the learned single judge, my lord, the operating portion at page number 14.
but you are the same person.
Yes, yes,
Some difference. in
ಸ್ವಲ್ಪ
sig-
difference ಕಾಣಿಸ್ತಾ ಇದೆ.
Now the direction is
Direction is to, my lord, page number 14, my lord, operating portion.
delete the name of the petitioner from rowdy sheeters.
Yes.
list. ಅದಿನ್ನೂ ಆಗಿಲ್ವಾ?
ಅದು ನಿನ್ನೆ ಮಾಡಿದ್ದಾರೆ, but
Then what?
gun license is also not renewed.
Gun license,
Rowdy sheeter and my lord, concerned authority is also directed to consider the request of the petitioner for renewal of the passport as well as renewal of the gun license within a period of 4 weeks. A passport renewal. ನಿನ್ನೆ ಇದು fourth condition is been complied yesterday, my lord. ಈ fifth ಇನ್ನೂ ಆಗಿಲ್ಲ.
now who is the answering respondent?
My lord, deputy commissioner is required to, my lord, comply, my lord, the now direction which is to be required.
issue notice to the third respondent for the present.
Yes.
AGA accepts notice for the fifth respondent. Relist. In the interregnum, the office objection to be complied.
Please.
Yes.
Sachin Mahajan,
My lord, initially the regular appeal was filed before the learned district judge, my lord, because of the confusion caused due to new amendment in pecuniary jurisdiction. And later on, it was the appeal memo was written by the learned district judge for the want of jurisdiction. And now we have already deposited the amount in district court account, my lord.
Why can't you ask there only? Now, you must withdraw and redeposit here. That is the correct procedure. We will give you time,
Yes, my
but you may have to seek for refund there. How we can ask for that?
if it is the same, may kindly be verified. My lord.
You move an application there.
Yes, my lord.
You keep this pending. Anyhow, this is there. Move an application there, seek for refund there. In light of the development. Then we'll see if we have to intervene.
I think.
List a week after next.
Some urgency in this
I
matter.
have to comply the office objection on the IA, my lord. The index I have not filled. I have to fill the index. If your lordship permit me to, I will, now itself I will apply the office objection.
There is some urgency in the matter, my lord. Suit for partition. Defendant set up an alleged will. The defendant did not enter the witness box even to prove the will. Suit was decreed, against which this RFA is filed by the defendant. During pendency of the suit, in spite of there being a specific order of temporary injunction not to alienate the properties, the defendant is on a spree to induct this thing by unregistered documents. We can't even place our hands on the document.
They are inducting.
This is alienating under unregistered agreements of sale. So we don't get any, if it is registered, we can obtain copies and file for contempt.
Suit is dismissed.
Suit was decreed. Partition suit.
The defendant appeal, my lord. First defendant appeal.
First defendant has preferred an appeal. She is at Bangalore. We are staying local.
Correct. Now you have filed your objection for that IA.
Pardon, madam? Yeah, in fact, the produced certified copy of will. Will original has to be produced.
Certified copy of the will I have
And
produced, my
in
lord.
fact,
Original
my
is
lord-
with the appellate respondents only, my lord. They are having, my lord, they are not giving to the will.
No, now you are pressing on IA or main or what is it?
Main appeal dispose ಮಾಡಿದ್ರೆ ಅನುಕೂಲ.
Oh,
Main
at
is
this stage,
concerned,
that requires hearing. isn't
ಅಲ್ಲ,
it?
in any case, that application for additional documents in appeal, it has to be heard along with the main appeal.
Correct.
So, so let the matter be posted for this stage only with an understanding that on next stage it will be taken up on. Because for final hearing, it may not reach. ಯಾಕಂದ್ರೆ criminal appeal ಇರ್ತವೆ before this honorable court.
Correct. There's some extraordinary case to take it out of turn. How we can take it out of turn?
So point involved is very short
Hmm.
in the matter. So,
The point.
sir, only they are raising a will, issue on a will, and they have not led evidence before the trial court. They have filed written statement. Intentionally, they went on prolonging the matter. And finally, after sufficient opportunity was being given to them, when they failed to lead the evidence, the matter was posted for judgment. And there also sufficient opportunity was given, and then the judgment has been passed.
Correct. Now it has to be heard.
Yes, sir.
In the absence of will, they are not a sharer is what you're saying.
Yes, ಇಲ್ಲ.
Then they are not
They are sharer along with us. They are claiming exclusive title
on the basis
to
of
the best will.
Correct. In the absence of that, they get along with the others.
Others, ಅಷ್ಟೇ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಇದೆ ನಮ್ದು.
Correct.
They claim defense of exclusive owners on basis of will executed. It is mother's property. Property of mother's property. So they claim mother has executed an will. That will has not seen the light of the day anywhere. For the first time, they purport to produce a copy certified by the chief officer TMC, Kembami. by certifying the document stating that it is a will. We have filed an application under RTI asking him whether we have got the original will to issue a certified copy. He keeps mum.
So we'll hear.
Stay there. Objection. Can you attesting witness? Objection left and to so updated soon.
No, no, I.
So even if the original, you want to need evidence, that original will has to be summoned. We don't know whether it is there in that authority or not there. Without seeing that, we don't know, we can't take your additional.
But
evidence.
certified copy I have produced, my lord, certified copy, on that basis mutation entries are there, my lord.
No, is it a registered document?
No, ma'am. No, not.
So then where is the original?
Original with the, my lord, the
No,
respondents only, they are not giving, they have taken from me, my lord, for getting the amount from the bank, my lord, in the.
Again,
That's so that requires hearing. At the time of hearing of the appeal, we have to appreciate.
well, according to us, that is a fictitious document. There is no such will.
Let us, that is your stand.
Yes.
Now he has to make out a case, whether additional evidence can be taken, etc. So we'll fix a date for hearing, let us.
Please.
So
list the
I have
matter.
filed 3 applications on the other day. One is not to induct any third person in the joint possession of the property.
It is
Or
already
I
granted by
have
your
filed
lordship.
2 applications or otherwise appoint a receiver, sir, because they are causing threat to all the persons involved in this litigation. Whether there is a will or not, that apart, sir. As of now, the decree has been stayed by this honorable court and they are using that as a tool to do all illegal activities. So either way, the property has to be protected in the interest of all.
Correct. Yeah. All are co-sharers.
Co-sharers.
All,
Yes,
isn't it?
Brother and sisters, my lord.
So then all of you have a right to enjoy it without the exclusion of the others.
yes.
So in that, what is the problem now? Who is in occupation?
They are
One
inducting by
submission.
unregistered doc.
Submission. FDP actually permission to. One submission, my lord. Since there is a stay, let it be modified so that we can file FDP till the drawing of final decree. Only the drawing of final decree we stayed that. Sorry. So that at least after this disposal, we have to again fresh file FDP. That will take a lot of time. To save time,
Will permit except drawing of.
except
final
let the
decree?
proceedings go on. Commissioner be appointed. Let him demarcate the shares. Let them file their objection.
Let,
Lordship,
uh,
can
So
a
that at
disposal
least
it may
there
be-
will be some this thing.
Yes.
Even I am ready for disposal in next week.
ಅದು ಆಗಲ್ಲ.
Court take time.
ಅದು ಯಾವಾಗ ಆಗುತ್ತೋ ಅವಾಗ ಆಗುತ್ತೆ.
Please.
Please.
The learned counsel for the respondent
1 to 4. I am the
1 to
plaintiff
4.
before the trial.
submits that the interim order passed by this court on
30th/5/2018, my lord.
35. On 30th/5/2018, that is the order passed.
Yes.
Yes. Admit call for record.
They have not filed, my lord.
Let it be
execution.
clarified
There it
that
is there.
filing of FTP is permitted.
That order is clear.
Already there, already.
They are drawing up a final.
Yes, ma'am.
Yeah, drawing up a final.
Let it be clarified that filing is permitted only.
Not necessary.
Clarify ಮಾಡಿದ್ರೆ ಸಾಕು, we can file.
Learned counsel for the respondent
ಅದೇ.
submits that the proceedings till drawing up a final decree can be permitted on the execution side.
Yes.
Notice the order of 30th May 2018, which by virtue of which there is a stay of drawing up of final decree. Accordingly, no further orders are required. As what is being stayed is only drawing up of final.
And not filing ಅಂತ ಒಂದು ಬರ್ಬಿಟ್ರೆ. And not filing of the proceedings is.
Clear. Now this order is clear. ಅಷ್ಟೇ.
ಅಲ್ಲಿ
Now-
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸ್ವಲ್ಪ ಸ್ಟೇ ಇದೆ ಅಂದ್ರೆ ಸಾಕು, they will not touch the.
Trial court cannot reduce itself to government officials.
ಇಲ್ಲ, that is true, my lords.
So I'm just
Oh,
saying,
ಅದೇ.
because many a time, justifiably so, lawyers come and seek clarification because government people are not.
ಹೌದು,
doing.
they.
Our trial court officers who are judges must not reduce themselves to that. If there's any problem before 28th, you move an IA.
Please,
Please.
Much of,
List in final hearing list.
please.
The week after next.
IA for additional document will be considered at the time of.
IA for additional document would be considered along with the main.
Please.
Next.
Next thing, Vijay.
Carry, mandala.
677 days delay in filing the appeal, my lordship.
Order number 1 of 24. Accepting the reason assigned in the memorandum of facts accompanied to the IA number 1 of 2024. So also considering the aspect that the applicant is in judicial custody from the date of
His arrest.
from the date of his arrest, the delay of 677 days in filing this appeal is hereby condoned. Accordingly, A 1 of 24 is disposed. Released after 2 weeks. In the meantime, the additional SPP is permitted to file objection if any to IA number 2 of 24.
He has been convicted under section 5R and 6.
6 of the POSCO Act.
POCSO Act. 5R, that is the
307 and 376.
Please.
5R,
5R and 6.
5R.
My lordship,
Admit,
name of the Sheshadri Jaishankar.
registry is directed to security QCR.
And also that name of the Jaishankar
Deleted. I
Sheshadri.
filed already, I filed memo of appearance.
His name may be deleted.
Registry is directed not to show the name of Sri Sheshadri Jaishankar.
Yes.
And since she so and so.
Sudhir Singh, already I filed memo of appearance. Appearance ಹಾಕಿದ್ದೀನಿ. ಹಾಕಿದ್ದೀನಿ.
The name of she so and so, sir.
Anand.
Yes.
My lord, the respondent authorities have not complied with the order dated 28/3/24 passed by this honorable court.
Right.
No, they have not complied, my lord. They have to release
What is the direction?
My lord, actually, the respondent authorities are holding the salary of more than 1 year of the complainant and also other monetary benefits, my lord.
Who is the paying officer?
Number
Fine.
2.
Number 2, my lord, the Commissioner, Kalaburagi Municipal Corporation, Kalaburagi.
Issue notice to the second respondent. First is not necessary for the present.
First,
Maybe at a later stage.
yes, my lord,
The notice to or first is the pro forma party.
pro forma party. my
The
lord.
AG accepts notice first respondent. The complainant is at liberty to serve Who's the standing counsel?
Sanjay M. Joshi sir is the
Huh?
Sanjay M. Joshi sir.
Sanjay M. Joshi. As regards second respondent, which is in addition to notice issue. Relist the matter on 24.
But 14, Ratna and Shivayogima.
Last occasion, my lords, after hearing, last directed me to whether clarify it, whether it's causes means a district rights comes under.
correct.
Yes, my verify my lord, he comes under.
Judgment ಏನಾದ್ದಿದ್ಯಾ?
Judgment ಇಲ್ಲ, only in respect.
So Orissa Supreme Court judgment with respect to a case from Orissa.
Yes,
With respect to an order was passed regarding allotment of sites by the joint registrar. So they went on registering the sites in violation of the interim order passed. So then they filed contempt. That was clarified in that judgment. Supreme Court
yes,
judgment
yes.
arising out of a matter in Orissa, wherein the same point, I'll ask my law clerk also to check. Just wanted to find out that one. We'll have it on Monday.
Yes, last occasion also during the penance for writ petition, my lord, he has district has violated that interim order and given some positive direction to the DD5. For that, I have filed the contempt. And then the notice was immediately after issuance of notice, he withdrawn that letter since it was contrary to the interim order.
Now here, what is the contempt complaint of?
Contempt, my lord, this honorable court, you yourself kindly see the ink page 46, my lord. Directed the respondent, district registrar, to prepare list of members as the bylaws of the society, and while doing so, he shall comply with the direction is issued by in the so and so writ petition. This shall be completed so and so within 6 days. Earlier in the writ petition, my lord, I have produced that earlier writ petition also, ink page 28, my lords, along with the list also, which are
Okay, you take out notice,
yes,
but
ma'am.
at that point.
Yes, meanwhile, I will also
Can clarify.
search, yes, ma'am, Orissa.
ತಲೆಯಲ್ಲಿ ಅದಿನ್ನೂ clear ಆಗಿಲ್ಲ.
Yes, I'll Orissa High Court note, Supreme Court judge.
So who now is the answering?
Government,
No, correct. Who is that officer now?
four district registrar.
DRCS.
Issue notice to the fourth respondent for the present. AG accepts notice for the fifth respondent. Relist on.
No, my lord, fifth respondent, none bad, private party there.
Pro forma, ಇಲ್ಲ.
Pro forma, you
Forma.
1, 2, 3.
Huh?
ಇಲ್ಲ, 5 is 4 form.
Five.
5.
Our
Please,
amendment
sorry, my lord, none order.
is on. So that case was wherein order was passed not to register sites in a house building society. These people went on registering the sale deeds, contending allotment was done earlier. What we are doing now is only execution of deeds. In that context, they had raised an objection saying the joint registrar under the Societies Act cannot be a court under 2. Some order is passed, just check it.
Only.
So Apex Court appears to have said, or Orissa High Court, that the joint registrar under the Act has all the trappings of a court because they decide like a court, evidence is there, etc., etc. So it can be treated as a court. Just look into it.
Yes, I searched, my lord, but
And
judgment is yes.
No done.
Only that the KAT order against order of appellate tribunal, we can't file any contempt. And nowadays, I have filed one writ petition to mandamus to implement that order.
No done.
Like instead of filing contempt.
Yes.
50, Nitish Padia.
For the complainant notes. The matter is a land loser scheme. The petitioner number 1 was appointed and he worked for 12 days minutes. And after then he gave a representation to the managing authority that he could not work under the mines. So he approached this honorable court in writ petition. There was a direction to issue appointment order to the petitioner number 2 minutes. Operative portion is at ink page 13, para 9 minutes.
So now who would notice must,
Please.
notice to the respondent. Returnable by.
Oblige.
Prashant, Vajan 3.
Kindly password, man.
Just 1 minute. Repatriation.
Yes, ma'am.
Let them get the stamp.
My lord, impugned order ಕೊಟ್ಟಿಲ್ಲ, annexure ಏನೇ ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ಸರ್ವ್ ಮಾಡಿದ್ರು.
No, I think they have come only against the interim order.
Yes.
Let's see.
Yes.
College will give. Now, KT will take it up on merits. Isn't it? Merits mele.
Yes, ma'am.
KT will take it up on the next.
No, no, my lord, the already identical matter, my lord, the coordinate bench already given the interim order.
Transfer, repatriation are like bail matters.
Alla, my lord, the coordinate bench, my lord, will give the documents.
Again, no dear. I'll have it on some other day.
No, look,
Repatriation only against interim. order.
afternoon.
Let him have a look at it.
In
Allah,
my case,
only
I
for-
moved the matter in the end of the list. It's not repatriation. By misconstruing that, I have, even though I transferred, so for that place, district hospital, Bidar, their name has been included in that list and the,
Is it connected?
ಇದ್ರಲ್ಲಿ
Same order, my lord, in the 21-1 order.
he included my name in this list.
Then,
ಇದೆ.
pass over. Yes.
Number 70, Preeti Patil.
Seventeen point one is await
Got it.
service of notice to R1, my lords.
Is a necessary party.
It is for them to decide, my lords. I have challenged for liability, my lords.
Who's
Connected.
R3?
Owner of the vehicle.
R1 is owner of the vehicle, my lords.
R3, isn't it?
In 17.1, I am submitting, my lords.
17.1.
Please.
Who is R3 in the first matter?
Same person, my lords.
Same person,
Correct,
lordship, he is
so-
held sufficient.
Now finally 3 times and then you take substituted service. Held sufficient.
Mine is held sufficient, yes, my lords.
You have taken out, it was
I have
served,
taken paper
served
publication.
unrepresented
I have taken paper publication, my lords. Substitute service I have taken.
after 3 times.
Yes, my lords.
You have to take independently. You have to take independently. You can't take their substituted as good for you. Issue.
I will file.
Office to put up report regarding notice issued to R1 in 17.1. Relist the matter on. Unless you decide that you don't want, that is up to you.
Please,
Next.
I will file.
The last date of hearing, your lordship heard this matter and directed me to file in writing with regard to the taking of the actual possession, my lord. My lord, off the record, I submitted, the officers are not ready to file, they are shifting, my lord, board ಕೇಳ್ತೀವಿ, ಕೊಡ್ತೀವಿ, ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. I have gone through the entire file. My lord, in the file, my lord, the amount deposited to Raichur court was returned back to the KIDB office, Dharwad. Earlier, it was situated in Dharwad, even Gulbarga, this area is also, my lord, was coming under the office of Dharwad. Later on, it was shifted to this Gulbarga. And thereafter, my lord, that amount was not deposited.
No, we have passed an order in writing for you to clarify. Isn't it?
Yes, my lord.
You give us the details of the official, we will note it down and we will say compliance of that direction by so and so. You tell us, designation of the concerned official, if not by name.
Kindly pass on my lord by 2:30. If they are ready, I will file my, I will inform them. 2:30.
Let us. Pass on.
Lord, in this case on
Yes.
In this case, on last date of hearing, Lordship had asked whether R.S. Siddhapurkar sir will undertake to file power for all, my lord. Madam says
For
she's
instructions in this matters, I will undertake to file wakalat on behalf of respondent number 1 in 14 matters.
Give us.
I will supply.
my lord, and in remaining matters, Lordship had asked me to prepare a list wherever there is office objection, where we are complied, what are, my lord, I have prepared a list in total in around 19 cases, my lord, compliance is there, it will be done within 2 days. It is only consul submission, whereas in respect of deposit of 7 lakhs rupees, in respect of consul submission, my lord, lordship in connected matters already kept the office objection in abeyance and issued notice, my lord, subject to deposit of 7 lakhs rupees. That can be passed, my lord. We have prepared a separate list. And the third one is with regard to non-filing of,
1 minute, one by one.
please, my lord.
Now, first.
First one is non-compliance of office objections.
You must send an email of this list
Please, my lord.
to the ARJ Kalaburagi.
Please.
So they can copy paste this.
Please.
Counsel for the appellant submits that office objections raised in some of the matters would be complied with and furnishes list of appeals in which office objections have been raised.
Please.
Accordingly, insofar as the following miscellaneous first appeals following a table act, the counsel for appellant submits office objections would be complied with. Yes, Krupa Sagar, next.
My lord, second one is in respect of consul submissions, my lord. In that, I have given the entire list, my lord. In connected matter, lordship has already kept the
By recording this submission.
yes, no, submissions have been kept in abeyance and issued notice to the respondents.
Correct.
Now,
So this is the explanation you have given the MFAs.
yes, my lord.
Individually, you have already given.
Yes, my lord. We have given already explanation, my lord. That the explanation lordship has kept the office objection in abeyance.
So we have to pass a common order.
Common order, my
In
lord, in all
these
this.
matters.
Yes, my lord.
It is submitted by counsel for the appellant that in some of the matters, the counsel submission may be taken on record and necessary orders be passed insofar as the interim order.
Yes, my lord. In lordship was, yeah, I have got the earlier in your order, my lord.
No, correct. Now this is what you have given.
Yes, my lord.
What is your prayer now?
Now interim order has to be granted.
Given.
Yes, my lord. And if other side gives me the list wherever she is going to appear, in that cases, I will serve them the copy. Remaining cases, I'll take out process, my lord.
ಏನ್ ಬಂದಿದೆ? Interim order, full stop. Memo filed enclosing copy of the interim order passed in MFA 202737 of 2022 on 6th January 25. Order reads as hereunder. Alert counsel for the appellant says an identical order may be passed in the present appeal as well. Accordingly, the noticing that this court in MFA 202737/22 had kept the office objection in abeyance and valuation made by the appellant came to be accepted, and noticing that similar office objections have been raised in many of the matters, list of which is enclosed by counsel for the appellant. And noticing the interim order passed in the aforesaid appeal, the office objection regarding valuation is kept in abeyance. The valuation made by the appellant is accepted for the present.
Please.
There would be an interim order taking note of interim order passed in identical matters on the principle of parity. And there would be a stay of
the award, judgment and award of the
order of the reference
court.
subject to appellant depositing a sum of rupees 7 lakhs per acre within a period of 8 weeks from today. The deposit shall be subject to result of appeal and shall not be released without order of this court. Upon deposit, said amount to be kept in interest-bearing fixed deposit. Now, then government is directed to file wakalat for the land acquisition officer.
I'll serve the copies.
Next, in some of the matters, so and so learned counsel appearing on behalf of R.S. Siddharth Purkar submits that they would undertake to appear.
Yes.
List is enclosed
Yes, sir. I'll
along
furnish
with the
this.
memo. Accordingly, office to show the name of so and so as representing the claimant
Yes.
in such of the matters as are listed below.
Yes.
Next.
Lord, third list is
Next, taking note of the memo filed along with the matters in which council submission is overruled and interim order is passed. The interim order as passed above would relate to such of the matters as are listed below.
please.
ಇದು ರೋಮನ್ 2 ಅಂತ ಹಾಕಿರ್ತೀನಿ, ಇದ್ರಲ್ಲಿ ಹಾಕ್ಬೇಕು. ಇದ್ರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಈ ಸೆಕ್ಟರ್. ಆಮೇಲೆ ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರ ಒಂದು ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ, ಅದು ನೆಕ್ಸ್ಟ್ ಟೈಮ್. You send everything by email to the ARG.
Yes,
So they can.
Lord, third list is in respect of non-deposit of the amount set interim order as direction. Lord, it has been deposited and we have filed the acknowledgement in MFA number 202723 of 22.
Counsel for the appellant has filed a memo and acknowledgement for having, which would evidence deposit of 7 lakhs in terms of the interim order passed. Said memo is taken on.
Said memo is filed in MFA number 202723 of 22.
Said memo is taken on record.
Please.
So you have deposited in all the matters.
Yes, my lord. In some cases, still 8 weeks has not been completed. It has still 8 weeks has to,
You file memos along.
please, my lord.
Yes,
Along with
please.
memos, we'll file and
Yes.
email the copy to the
So now, what remains?
Lord, we will.
The preliminaries.
Yes,
What are
we-
merits?
But there are 10 other matters, my lords, in which I am yet to receive instructions to file wakalat on behalf of the claimants.
Another-
2 weeks time may be granted. I will seek necessary instructions and file wakalatnam on behalf.
What about merits?
Lord, meanwhile, Lordship can direct both of us to file a synopsis. Based upon that synopsis, my Lord, Lordship can dispose of the matters by the, by,
The point, what is the point in?
my Lord, point involved is, my Lord, after remand of the matter, sale deeds which are not, the sale deeds, which are not concerned to the same notifications has been looked into and an order has been passed. Short point, my Lord, only that point senior is engaged. Any date, in from.
Sale deed is not relating to this.
Yes, my Lord,
local
based upon that, sale deeds,
That is the only reliance.
yes, that is the main reliance, my Lord. Main,
So you're saying it, the refixation must go
yes, my
and
Lord.
it must be sent back.
Yes, no, it was, already it has been sent back once. Now again, the same thing has been done by, but there are some lapses on our part also. That's why if Lordship hears on merits and it can be disposed of.
Is
Yes, my Lord, it can be
Copy of
disposed of. I'll furnish all the copies.
Both sides who are on record are to file their synopsis
Please.
by the next date, consisting of list of dates, summary of legal contentions, and authorities relied upon. It is noticed that identical issues would be in consideration in all matters. Accordingly, both sides to be ready on the next date. 10 days argument on date. Let us. No, 10 days you
La-
get it.
In between, my lord, if matter is posted on 12th or 13th, the non-compliance matters, same orders can be passed and a date can be fixed, my lord.
Relist on 12th,
Please, my lord. 13th, my lord,
13th.
please.
Let us see.
In the meanwhile, they serve the copy.
I'll serve it, my lord. I'll serve in all the cases.
PCR to be summoned. to
There are
court.
three batch of reference of club matters, my lord. They may,
Give a memo, given from where we have to summon.
yes, my lord.
Give the details.
Please,
PCR to be summoned.
please, my lord,
Give it in writing to the court of.
please.
Obliged.
Yes. Okay. Password.
And
21 AD.
Kindly password the matter, my lord.
Password.
Sooner resign.
Also.
22. Manvender Reddy,
Yes, what is the contract? You are the,
I am the plaintiff, my lords.
you are the agreement holder.
Yes, my lords.
Ah,
Registered agreement of sale, my lords.
Ah.
Suit is dismissed on the count of delay, barred by limitation, my lords.
Was any date fixed in the
In
agreement?
the agreement, there was a date fixed for 1 year, my lords. But full difficulty was, my lords, by the time that 1 year was completed, my lords, the pandemic COVID had started. Thereafter, my lords, even then, my lords, there is a round gap of around 1 year, my lords, for filing the suit.
So now despite extension, still it was barred.
Yes, yes, my lords.
Then how
Around
do
6 months, my lords.
How do you get over that?
Here is the case, my lords, wherein the registered agreement for sale is there, my lords. More so, my lords, the court, there is no denial from the defendants, my lords. In view of the amended act, my lords, since in view of the circumstances that there was a pandemic COVID, my lords. The,
Now, unless you say,
yes, my lords.
one is by virtue of the order of the apex court, it came to be extended.
Yes, my
I
lords.
think 2 years or something.
Yes,
isn't
my
it?
lords. 2 years, 6 months, my lords.
2 years, 6 months.
Yes.
Unless you say there was something else he was required to do of some record or something like that, so that you can claim the benefit of extension.
Yes, my lords.
The trial court would have said 3 years from the date of X. Isn't
Yes.
it?
Now, the trial court has only taken note of stating that, my lords, only 1 year time was fixed, my lords, since there is considerable delay in filing the suit, my lords, as such suit has been dismissed.
That
Even,
extension, it has not taken note of that.
no, my lords. And the honorable court has, the defendant has also not filed return statement also, my lords.
He has not filed.
He has not filed return statement. And it's a registered agreement for sale, my lords.
So
And there is no denial. A notice was also issued prior to filing of this.
he has cross-examined, no.
Yeah, no, my lords.
He has not cross-examined.
No. Operative, point number 4, my lords, regarding
No,
limitation.
court has taken note of suo motu extension.
Yes, so motu extension is taken note of, my lords. Subsequently, my lords, considering the fact that there was some vacuum which was created after the pandemic, my lords, the party could not approach the advocate to issue notice, my lords. So immediately, my lords, notice was issued, and even thereafter, my lords, the suit was came to be filed, my lords. There was no reply to the notice also, my lords. Neither after having served with the summons, my lords, he has appeared through a council, my lords, but he has not filed written statement.
To take out,
Please.
issue notice on main as well as IA to the respondents. ECR to be summoned forthwith.
Please. Lords, may I seek, my lords, injunction not to alienate, my lords? Because that is the only application relief I am seeking as of now, my lords.
Taking note of the contentions made and the assertion that the sale agreement was a registered document.
Yes, registered document.
Subject to further consideration, respondent not to alienate the property. The subject matter of the agreement, specific performance of which is sought for.
Yes.
Number 24.
Obliged.
Hearing for the appellant, my lord. Conviction appeal. The appellant is convicted under section 307, my lord. And there's section 12 of the POSCO Act, my lord.
Issue notice. to
My lord,
respond
is
number.
please, my lord, is the local Gulbarga, my lord, the next week, my lord, any date.
Actually, the notice has to be served.
Please, my lord. But he is the residence of the Gulbarga, my lord.
Additionally, additional SPP is connected to intimate the concerned,
Please.
intimate the respond number 2 through concerned police.
Please. Next week,
Meantime, the registry is directed to secure the TCR.
please.
Denotify after 2 weeks. Meantime, learned SPP is directed to file objection if any to IA 1 of 25.
Please.
Yes.
Petition is nothing but a mercy petition before this court, my lord. The petitioner is an employee working as Sarastad in Krishna Jalam. And he was trapped for taking 5,000 rupees for change of khata, my lord. An inquiry is held, charges are proved, and a punishment was given 50% of pension amount to be reduced. Considering the nature and other circumstances, the punishment imposed is hard. Any relaxation, I seek only. KT has held.
Annexure A5 is the order of the government, my lord, where
Supported.
Yes, exactly. I am before.
And acceptance
My
proved.
lord,
Demand and acceptance proved.
that I was before the court only on the mercy because even department inquiries charges are held. The scope is very limited. Instead of 50%, some concession considering the
Get some authority in respect of the proportionality of the punishment, excessive discretion.
yes, see here is
Proportionality. of
proportional.
punishment. Discretion is leftover to the court.
I'll come over with judgment.
Judgments required. Because interference in D or
The very,
judicial review is very limited.
very limited. I,
Proved very limited.
no, no, I have conscious of this, my lord.
So you show us if there is any window, let us.
Yes, yes, yeah. Yes, I'll, next week, 12th or 13th, any day,
Relist on.
13th.
Lords, may kindly be taken next week, my lord.
My lord, this, may I make one
My lord,
suggestion?
go
Here, my lord, the, have been imposed with a major punishment, my lord. And my lord, there are no, my lord, C&R rules as on the day of initiation of departmental inquiry against me. My lord, they have imposed, my lord, the entrusted departmental inquiry to the Honorable Upalokayukta under 14A, which they could not have been done, my lord, because there was no, my lord,
No
they
rules.
have not adopted those rules at all,
They have not adopted.
not adapted. And even I have produced, my lord, the rules and the, my lord, in the year 2014.
We'll grant time, but let's see what the point, and then we'll grant you time. We'll see what the point is. You tell us what is it that he has to answer?
Yes,
You point us what is the point you're making. There were no rules at all.
no rules at all, my lord. And my lord, there was,
The employer,
my lord, he is, my lord, working, my lord, as a Khadi board employee.
uh,
My lord,
don't
he-
they have any disciplinary rules?
yes, my lord, it came into force, my lord, immediately after, my lord, this initiation of this departmental inquiry. Lordship, may kindly see, my lord, their rules, my lord, at page 122, 122, annexure R,
120.
122, 122. My lord, on 12/9/2014,
Yes.
my lord, these, my lord, the notification was issued. And Lordship, may kindly see, my lord, page 123, rule 3. Page 123, rule 3.
Yes.
The provisions of the Karnataka Civil Service Classification, Control and Appeal Rules 1957 and as amended from time to time shall mutatis applicable in respect of employees of the board subject to such modifications specified in Schedule 4 regarding the disciplinary authority, appointing authority, appointed penalties.
No, but just tell me, it cannot be that before 2014, there were no rules at all for those employees.
My lord, here, there may be, my lord, some rules, regulations, my lord, that apart. My lord, when it comes to, my lord, the entrustment under 14A,
That cannot be done in the
it cannot
absence
be
of
done.
rules.
And now Lordship may kindly see the entrustment order.
You just check by next week. I passed some order sitting in the service bench in which PM Nagbhushan appeared. PM Nagbhushan advocate appeared on this point of whether it could be given retrospective effect rules, same point, entrustment, absence of rules. We set it aside saying that there cannot be retrospectivity cannot be given to the amendment. So for entrustment to Lokayukta, unless there was any provision, as on the date of entrustment, you cannot date it back. Same on the same point. Just check.
Yes, my lord. I will, my lord, one more submission, my lord, here. Even, my lord, if there is some entrustment, it should be from the government. Entrustment should be from the government. Here, my lord, the Khadi board, my lord, the CEO, my lord, he cannot entrust and he cannot impose penalty.
Now, who's the disciplinary authority?
Disciplinary authority, my lord, there are no, lordship may kindly see, my lord, the entrustment order for a moment, which is at
Correct.
page.
Now, you're the employee of the Khadi board, is it?
Yes, ma'am.
So the employer, it's a society or what?
My lord, employer is a board.
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 So the disciplinary authority is the board only.
Disciplinary authority should be the board if there are some disciplinary rules.
Correct. How can the government come? Because these are statutory corporation like.
Yes, ma'am.
Where the chief executive of the board or the board will be the disciplinary authority. How will the government come here?
But government will come only for the reason, my lord, when there is 14A is invoked. And, my lord, the Lokayukta Act and CC rules, my lord, this comes into picture. Because entrustment should be done by the government.
For which, under their rules, there must be a provision.
Under their rules?
For the government to entrust.
Yes, my lord. There is no such, my lord, and they invoke 14A specifically.
So the CCA was made with effect from 2014.
And that is, my lord, 12/9/2014. This
when was-
entrustment is on 3/7/2014.
3/7/2014.
Which is at page 23.
But eventually, we may have to keep open. When is the incident?
That the incident, my lord, it relates to 2011. And now he is already retired, my lord. He is nearly around 70 years of age, and 50% of his pension has been permanently, my lord, is reduced.
So correct, but now the only point, just consider, suppose an inquiry is set aside. On the ground, there was some technical lapse. And if the inquiry was initiated within the time permissible under law, and if it goes without on merits, then liberty will have to be reserved to do it as per law.
But in the instant case, my lord, the allegations, my lord, are with regard to, my lord, that he has accepted some bribe amount. And that was very much dealt in the criminal proceedings, which ended in acquittal long back. And this departmental inquiry, because of these, my lord, deficiencies, my lord, and thereafter it has, my lord, culminated in, my lord, the punishment.
So the evidence in this case supports or does not support?
My lord, I haven't gone through the, my lord, the details in the criminal proceedings, but he was acquitted in criminal proceedings.
No, correct. In this, what has happened? Inquiry was held, not?
The inquiry was held, my lord, and he was, my lord, given in punishment of, my lord.
Correct. So have a look on merits also. In the event, we are to give you a clean chit, and then have a look if on merits also you have a case. Suppose we are to set it aside on the ground, no power of entrustment.
Yes.
Then normally what I do is, we is to give liberty to do the inquiry in accordance with law. If you want a clean chit, you have to show the evidence also. Or we set it aside on this ground, subject to what they say. And leave liberty. If they are so advised, it's up to them to do. Either do it or they may drop it. We can keep that option open.
Yes, my lord, in the.
Considering that you are retired, we can leave it to them to take a decision.
But in the normal circumstances, my lord, lordship has suggested, my lord, the liberty, my lord, can be. But in the instant case, he has retired, and the incident of year 2011, and my lord, this criminal case, my lord, has ended in acquittal also. But at this stage of time, my lord, whether inquiry would be, my lord, even, my lord, if.
Look into that point. Look into that point and give us something, let us. Now you get only on that point. You make
In
a
the
small-
operative portion of the order, the CEO Gramodyog has stated, my lord, ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ ಅಂತ KCS ಇದನ್ನು
Correct,
ಅಳವಡಿಸಿಕೊಳ್ಳಲಾಗಿದೆ.
that is done
When-
later,
yes.
that's done later. So then there is, as on that date, if there is no power of entrustment, just
Only entrustment power is there or not?
Yes, my lord. Others,
That is the only point.
yes, my lord.
Relist on Monday, Tuesday.
Yes.
Monday, na?
Tuesday.
Monday.
Tuesday,
Tuesday.
on the same stage.
Any
Get
of-
get ready, get ready. Answer both the points. Make a small summary, one date, etc. Have a look at that order. Now, if we are going to give a clean chit, then on merit summa, you tell us if there's any judgment explaining when the court may, because the long gap, use discretion to leave it. Otherwise, if there's a technical error, inquiry started within time, normally it back, preserving liberty. We can at the most say it's up to them to decide whether, since you are retired, whether they want to continue or not, we can leave it at. Yes.
But respond number 2, my lord. here.
ಯಾರು respond to-
ಅದೇ ಚಂದ್ರಶೇಖರ್
Government ಇದ್ರು ಅಷ್ಟೇ.
Yes.
For respond, my lord, counsel for respond number 2, my lord, they are not appearing. ಮೊದಲು appear ಆಗಿ.
Who is that? R2 is
ಅವರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಚಂದ್ರಶೇಖರ್
Khadi Village Board, then
ಖಾದಿ
Khadi Board.
appear ಆಗಿ.
Representation for R2 is made clear. If the said council is not present on the next date, court would be constrained to hear the matter in their absence. Copy of the order to be communicated by the registry to R2.
Please.
Yes, yes. Yeah.
Yes, Mr. Anil, which is your matter?
Serial number 36.
36.
Murder and attempt to murder, injured eyewitness. There are 12 injured eyewitness to the incident. 37 injuries on the body. Appeal is against the, before,
Just a minute.
so before submitting, my lords,
Report for the filer and
not to put there in.
yes.
my lords, before the last state of hearing, my lords have directed me to prepare in
Be
criminal,
ready.
criminal appeal number 34 and 30. So let the defense argue the matter and
We'll take
230 I'll,
We'll
No,
take
this will
230
give-
I'll.
will accommodate.
Yes, my lords. And I'm ready in serial number 34 and also state appeal in serial number 37.
I will do your job also.
Take up.
Since I have got very restricted submissions in this appeal, I know the limitations of this case. I have got very restricted submissions. So I will take over his role too and make my submissions. Lord's appeal is against the judgment and order of the learned first additional session judge Vijaypur in sessions case 163 of 13, wherein the appellants were held guilty for the principal charge under section 302 of IPC. and all were sentenced to life. They were also convicted for the other allied provisions of IPC and awarded various sentences. But the principal charge for which they stood convicted is under
All the
section.
accused are convicted.
All the accused.
1 to 6.
With the aid of 1 to 6 with the aid of 149 of IPC.
Yes.
Lords, appellants 1 to 6 were arraigned as accused numbers 1 to 6
Yes.
in SC 163 of 2013. Lords, the deceased and accused numbers 1 and 2 are inter se related. Deceased Sabu is the elder brother of accused number 1 and 2.
Elder brother of?
Accused numbers 1 and 2. 3 and 4 are the sons of accused number 2. Accused number 5 is the wife of accused number 2, and accused number 6 is the wife of accused number 1.
A6 is wife of
Accused number 1. Lords, the place of incident is a village called Logavi in Vijaypur Taluka and district.
All are convicted for life.
Life.
Life. So they all are in custody.
Accused numbers 5 and 6, they were granted the benefit of bail during the course of trial. And now this honorable court has suspended the sentence.
5
and 6.
1 to 4 are in custody.
1 to 4 are in custody right from the date of their arrest.
From last
10/6/2033. From 10/6/2013, they are in custody.
almost 11 years, sir.
11 years, 1 month.
ಇದೇ ಮಿಸ್ ಆಗಿತ್ತೆ 11 years.
Yes.
The place of incident is a village called Logavi in Vijaypur Taluk and district. To be more precise, it's on a lane in front of house of accused number 2 in Logavi village. It's on a lane in front of the house of accused number 2 at Logavi village. Lord, there existed a dispute between the accused on the one hand and the deceased on the other hand in respect of share with regard to ancestral properties of their elders. I mean, in respect of the ancestral properties of theirs. The deceased is the elder brother of 1 and 2. It is the case of the prosecution that deceased was given lesser share in the ancestral property. And in that regard, there were the litigation was on before the civil courts in Vijaypura. Both the parties have filed civil suits against each other, and they were pending before the civil courts at Vijaypura. Lord, with this backdrop, my lords, on 10/6/2013 at about 8 a.m., it's alleged that deceased left his home on the pretext of attending temple to attend a puja at Barmappa temple. He was on his way, and it is alleged that accused numbers 1 to 6 waylaid him, and they were armed with weapons like axes and clubs. The allegation is that they all assaulted the deceased indiscriminately. Deceased died on the spot. And PW1 Somaka, it is the case of the prosecution, witnessed the incident. There are a couple of other witnesses too who have witnessed the incident. And after committing the murder of deceased Sabu, they went in search of his son. higher center at Miraj in Maharashtra. He was there for about 1.5 months. He was admitted as inpatient. He survived that. He has sustained about 23 injuries.
So Somaka witnessed that.
Somaka is a witness to the assault on both Sabu and Mayappa. PW8 Kenchappa Rolli is another eyewitness. He is a eyewitness to the assault on Sabu, deceased Sabu. He has turned hostile. PW 14. Hanumant Biradar is an eyewitness to the assault on injured Mayappa. He has turned hostile. PW 15 Mahadevappa. Mahadevappa, he too is an eyewitness to the assault on Mayappa. He has turned hostile. And of course, there is PW4, who is an injured, who would speak about assault on his person.
So in respect of the assault to the deceased is concerned PW.
One Somaka,
PW1,
PW8 Kenchappa Rolli,
PW8,
Kenchappa Rolli, PW11 Dyamanna.
PW11 turned hostile.
He turned hostile. That's
What about PW15, 14 and 15?
PW14 hostile. PW14 he turned hostile. PW15 turned hostile.
Also turned hostile. So now PW1 and PW8 in respect of assault to the deceased.
Sabu.
Now, as far as PW4 is concerned, PW1
PW1,
is the only.
PW5, the wife, she, according to the prosecution case, is also a witness to the assault on Mayappa. But if her evidence is perused, it is her categorical statement that villagers did not allow her to see the incident. She was not allowed to go over there. Fearing attack on her too, the villagers did not allow her to approach the husband. So
PW1 and PW5 anyhow.
yes,
She
yes,
support-
yes, she
The
supports.
prosecution projected her as an
I witnessed to the incident of assault on Mayappa.
Mayappa.
How? My lords, as I've already.
Yes. Now, come to the
My lords,
complaint. When is the complaint registered lodged?
it's on the very same day of the
Ah.
incident.
So what about the
10.
incident? At what time? 8 AM.
8 AM. 8 AM is the Nandu 5.
8 AM.
How?
The deceased Sabu was proceeding
To Barmappa temple.
of the place. Where is the place of incident?
It's on a lane opposite to the house of accused number 2.
Opposite the house of accused.
Accused number 2, Lakappa.
A2 Lakappa.
Papa.
Yes. 8 AM.
8 AM.
So PW1 witnessed the incident.
How?
So what is the weapon used by these accused? number one and
A1 X
A1X
and stone.
and stone. A1. A2
A2 again, my lords, A1 and A1, A3 and A4, they used X's.
A1,
A3 and A4.
A3 and A4.
How? A2 stone.
A2 stone
How?
by A2
A2. A5 and 6, they used clubs.
clubs.
How?
A5 and 6.
6 clubs.
So 5 and 6 are women folks.
Woman folk.
So So this incident caused about 8 AM,
How?
8 AM,
How?
8 AM.
On 10/6/2013.
Thereafter, 10/6/2013, when the complaint lodged,
It was lodged at 10:30 AM.
10:30 AM.
How?
So immediately after the incident, they lodged the complaint.
how.
Exhibit
Exhibit P1 is the complaint.
P1
How?
by PW1.
Somaka,
By
PW1
PW1.
Somaka, wife of deceased.
Yes. Before whom? Exhibit P1 lodged before?
Tikota PS.
No, PW?
My lords, it is PW. Nachiket, PW 19.
Before PW 19.
How? Nachiket Janagowda,
PSI,
PSI of Tikota PS.
So FIR registered. When the FIR registered?
How?
Immediately, FIR registered.
How? 10:30 AM.
In crime number?
In crime number 63.
63 of?
Sorry, 64 of 13.
64 of 2013.
How?
By PW 19.
19.
As
F-
per
FIR Exhibit 21.
Exhibit P21.
How?
Thereafter, who went to the spot?
My
Spot
lords,
master conducted-
initially
Hmm.
the investigation was done by the PSI
PW 19.
19 and thereafter the investigation was taken over by PW 20, Chetan R.
PW 19 conducted, PW 19 drawn the spot master.
My lords, spot measure is drawn by
So immediately after the incident,
Exhibit.
that is after 10:30, after register of FIR.
How?
Hmm.
PW 19 and 20. The spot measure and all the major investigation was done by PW 20.
Yes, PW,
Chetan.
PW 20 is the PSI or PI?
PW 20 is the additional superintendent of police.
ASP, additional SP. Yes. Now spot master exhibit.
My lords, spot measure is exhibit.
P2.
Illa, just a minute. It is exhibit P2. Madam, Nurpuri exhibits not for me.
Exhibit P2.
How?
After the incident, they immediately rushed to, they, all the accused went in search of this PW4.
4.
They assaulted there.
Yes.
Then who shifted PW4 to hospital?
My lords, the villagers shifted him to district hospital Vijaypura.
So district hospital Vijaypura.
How?
Yes, he was admitted there. When his statement recorded?
My lords, his statement was recorded after 8 days.
After 8 days.
How? At
He was
Miraj.
seriously injured.
How? Approximately 8 days at Miraj.
Exhibit though?
My lords, he has supported, so his statement was not marked.
Not marked.
How?
Support 161 only.
161.
Yes. So now in the meantime, this inquest Panchanama conducted.
How? The inquest was done at exhibit P4. PW6 is the
Exhibit P4.
P4.
P4. Who are the witness for exhibit P4?
My lord, PW6 and PW7 are the witnesses.
6 and PW7
How?
drawn by PW20.
How? PW20.
So this 6 and 7
They have turned hostile.
hostile.
How?
They not even identify the injuries.
Illa.
Ah.
They say that they have their signatures were obtained on blank papers.
What about PM next? Postmortem?
Postmortem was conducted by PW. Lords, it's PW 16. Dr. Mehboob Bagli.
PW 16. medical officer.
Oh, medical officer who conducted the autopsy.
As per exhibit,
P17.
exhibit P17.
Oh,
What is the opinion?
death is due to hemorrhagic shock.
Hemorrhagic shock.
As a result of injuries to the deceased.
How many injuries?
My lords, total of 29 injuries.
29 injuries.
Oh.
Indiscriminately assaulted.
Oh,
Brutally.
oh,
29 injuries.
oh.
Yes. So after PM, even the accused arrested,
10/6/2013.
all the accused.
All the accused.
10/6/2013.
Oh,
Same day.
same day.
Same day.
Oh,
They arrested.
they were arrested near a petrol
Now-
bunk.
Now tell us the voluntary statement of accused. Now A1.
Lords, certain incriminating articles were seized at the behest of the accused, but the punchas to the recovery of articles have turned hostile.
Let us
He-
see.
he wa-
A1 at the instance of A1.
Yes, my lords.
A1 is voluntary statement marked as
It's exhibit P29.
A1 exhibit P29.
P29. Oh,
What are all the recovery now?
my lords, let me first finish the
Yes,
exhibits.
yes.
Voluntary statement of A2 is exhibit
A2,
P25.
P25.
Oh,
Ah,
A3 is P26.
exhibit P20, 23,
6
26, sorry.
of A3.
A3,
Of A4, it's P27.
P27,
Of A5, it's P28.
P28,
Of A6, it's P30.
exhibit P30. Whether it's a joint recovery or individual,
My lords, it's a joint recovery.
joint recovery. Now, what about this X used by A1 and A2? It's seized under.
My lords,
Now, based on the voluntary statement of A1, that is exhibit P29, and A2, exhibit P25, what are all the recoveries?
my lords, the Panchnama. Exhibits P6 and 7 are the Panchnamas.
Exhibit P6 and P7.
P7
Ah,
are the Panchnamas for the seizure of.
recovery, seizure.
Yes, yes.
Seizure of.
Soil at bus stand, medium-sized stone
Ah,
that was used in the offense.
ah.
A broken handle, MO8. Bloodstained clothes of accused at exhibit P7, MO9, 10, 11, and 12.
Whose clothes?
The clothes of accused.
Accused,
Oh.
one or all the accused?
My lords, all the accused.
All the accused. All the accused.
Oh.
Yes to MO?
MO9, 10.
Ah.
Sorry, it's of deceased. I am
This must be deceased.
deceased.
Ah.
It's of deceased.
Clothes of the deceased.
Oh.
Exhibit P6 and P7,
Oh,
under two mahazars.
two mazas.
MO9, 10.
They belong to the deceased.
MO9 to MO9 to
MO9 to 12.
9 to 12.
Oh, accused they already. Caesar Panchnam.
This is owned by the deceased at the time of incident.
Oh,
ಈಗ ಇದಕ್ಕೆ ಬನ್ನಿ. The recovery of these weapons used for the crime.
my lords, it's at exhibit P2.
Exhibit P2.
P2. The punch is PW2. MOs are 16 to 31. 16 to 31.
Pancha PW, 2
2, he turned hostile.
13 to
MO 16 to 31.
16 to 31.
How? Dhoti, banan, X with handle, shirt, track pant, X with handle, T-shirt, track pant, bamboo stick, sari, blouse, bamboo stick, sari.
Exhibit P2 must be spot master, no? So
And
just
also,
see,
and also Caesar is.
And also Caesar.
from the spot only they see.
Yes,
Spot and Caesar is.
Huh?
7 page number.
From the spot only they see, right?
Yes, my lord.
And then the accused took them to the place where certain incriminating articles were. It's a joint panchnama.
So all the accused,
How?
from all the accused.
From all the accused.
So who are the witness for this?
PW2.
PW2 only.
How?
He turned hostile. Huh?
And PW13.
PW13.
How? Both turned hostile.
This also drawn by PW20. Huh?
2020.
Yes. Now come to the evidence of PW1.
Lords, before that, as I have submitted, my lords, my submissions would be very restricted in this case. My first endeavor here would be to convince the court as regards to accused numbers 5 and 6. Whether there is any complicity of these two accused in the incident would be my first submission. If they go out, then I'll deal with accused numbers 1 to 4. My lords, for that, I'd like to take my lord's attention to the evidence of PW9, the independent eyewitness to the incident. Sorry, PW8. It's at page 125.
Yes, PW8.
126, Kenchappa Rolli.
Yes, yes.
The adjacent house at Logave belonged to Boramma. Now Sabu is dead. I know the accused persons present before the court. I know PW1 Somakka, PW4 Mayappa, and PW5 Ambakka. The complainant side owned land. I know land dispute between the complainant and accused persons. There are 2 temples in our village. Whoever visits Bharmappa temple, he will have to go in front of my house. About 2 years back, the deceased Sabu was going in front of my house to visit Bharmappa temple in the morning. It is approximately at 8 a.m. At that time, I was standing in front of my house. There were about 4 accused persons. This is very important. There were about 4 accused persons. I do not know who was armed with axe and sticks amongst the accused. One among them armed with stone and other 3 accused armed with axe. So the allegation is in respect of accused numbers 1 to 4. Then as an afterthought, my lords, the woman accused numbers 5 and 6 were also armed with sticks. As an afterthought, he adds accused numbers 5 and 6 to the case. The woman accused persons also assaulted with stick to deceased Sabu. The other 4 accused persons were also assaulted to Sabu, by which he died on the spot. The complainant PW1 Somakka came there. I tried to intervene the quarrel. When the complainant wife of Sabu came there, I kept quiet. I do not know after the assault made by the accused to deceased Sabu where he went. I cannot able to identify the stick X used in the assault. The police have not recorded my statement. So my respectful submission at the outset would be a concerted effort was made by the complainant party to rope in not just the men folk, but the women folk of the house to see that the entire family suffers. Obviously, there is a dispute in respect of the landed property of the ancestors. Lords, And again, the logic that follows is when men are armed with weapons like axes and stones, my lords, it's unimaginable that women folk would interfere and do their job with sticks when they are already doing it with deadly weapons. Why you need gloves to attack a person?
What is your cross-examination to that effect?
My lords, mine is a case of total denial. So basically, I am not relying on cross-examination very much. And again, my lords, to substantiate this, I would like to take to the evidence, my lord's attention to the evidence of PW 11, the Amanna. My lords, in my view, he too is a very important witness, so as to rule out the participation of these women.
PW 11.
11. He turned hostile.
Hostile.
Yes, but I would like to, my lords, just bring to the notice of the honorable court the cross-examination done by the public prosecutor in that regard. My lords, PW 11 at page 132. I do not know how Sabu died. I do not know who assaulted Mayappa. I am not stated to the my lords, he turned hostile. I have not stated to the police as per exhibit P8. Now the trend of cross-examination may kindly be perused, my lords. It's by the learned public prosecutor. He treated the witness as hostile and cross-examined her. It is false to suggest that on 2/8, the date is mentioned wrongly. The accused persons armed with blood-stained clothes, armed and with stick and axe and inquiry about Mayappa assault and assaulted and took to the land of Kannur. It is false to suggest that I have stated to the police that accused pushed Mayappa to the ground and A1, A3 and A4 assaulted with X. It is false to suggest that A2 assaulted to the leg of Mayappa. It is false to suggest that to help the accused person, I am deposing falsely. Not even a mention of A4, A5 and A6. This is by the cross-examination by the learned public prosecutor representing the state.
Now, what is his 164 statement?
161 statement.
161 statement.
My lord, so the 161 statement is marked at
Was it stated in respect of A4, 5 and 6.
You take it.
This PW 11 and PW 8.
Madam, records. In fact, his 161 statement ought to have been marked by the learned public prosecutor. That is not done.
Not marked, right?
Not marked. Once he turns hostile,
It has to be marked.
it has to be marked.
Who conducted the trial? You have not conducted the trial?
No. 161. Lords, the defense that was set up before the trial court was that he was addicted to alcohol, deceased. He used to pick up quarrels with the accused party. And on that day too, it is alleged that he was under the influence of alcohol and he picked up quarrel. So an effort was, in fact,
So what happened? He was under the influence of alcohol.
alcohol.
Hmm.
He picked up quarrel with the accused party,
Hmm.
and it is alleged that
All of a sudden incident
they
caused the.
under grave and sudden
Grave and sudden
provocation.
provocation.
They,
They are the
in
aggressor.
paragraph 48 is perused of the judgment at page 262.
So he was the aggressor, Antla.
He picked up quarrel and enraged by.
He was the aggressor, Anta.
How?
Page number?
262, paragraph 18, for paragraph 48. The learned, got my lord's
Yes,
quote.
yes.
The learned defense counsel, when posted for arguments, finally advanced arguments that this is not this is a case not of murder, but it is a case which is at the most believable under section 304 part 2. The defense which is set out in this case is almost given prosecution to win the half battle, that whatever the cross-examination suggestions or discrepancies shown are nothing but they are all minor. This leads to go to show that there was assault, and that at about 8 a.m. when Sabu was going towards Parmappa temple, he was waylaid, assaulted, and not only that, defense counsel could not be able to make out from his defense and failed to transact and note the fact that after murderous assault to Sabu, accused persons went towards Mayappa by any common prudence. No person could have been believed in an ordinary course of transaction that it is Sabu, due to his addiction to liquor and picking up quarrel, that provoked the accused, and accused without any intention to murder, but only had knowledge that weapons used in the assault likely to cause death of the victim.
Even otherwise, rightly appreciate.
With these submissions, I rest my hand.
Now, as far as the assault, 27 injuries are from 27,
39 injuries.
9 injuries caused to the deceased. And the incident was not caused in a sudden provocation. There is a motive behind. It's a clear motive. And even after the incident also, you acted in a cruel manner. You once again went in search of that
PW4.
PW4. So 5 and 6. A5 and A6 are concerned. They also stated that they assaulted with these bamboo sticks. Whether recovery aspect too from their end?
Their end, but the panchas have turned hostile. There is recovery of clubs. The bloodstain.
PW1 and PW4 supported. So they have stated the role of
Accused numbers 5 and 6.
5 and 6.
Since the independent witness is not consistent enough, PW1 and 4,
Is there
they.
any blood stain found on this one?
Yes.
This bamboo sticks also
Bamboo stick, blouse, sari,
worn by the accused.
owned by the woman folk.
This accused number 5 and 6.
5 and 6.
Sent for FSL.
It's FSL. Blood stains were found. So my submission would be in respect of accused numbers 5 and 6, since the panchas have both turned hostile for the recovery, the evidence is not consistent enough to bring them under the ambit of section 302 of IPC. Insofar as accused numbers 1 and 4
these accused number 5 and 6 were not there, huh? They were not assaulted.
He,
Afterthought of the.
afterthought, my lords, it's at page,
Initially, he has stated that. these
only
four
accused numbers 1 to 4, page 126. My lords, may I, at that time, my lords got it, my lords? It's at line 6 of second paragraph. At that time, I was standing in front of my house. There were about 4 accused persons. That is his initial statement. I do not know who was armed with axe and sticks amongst the accused. One among them armed with stone and 3 accused armed with axe. This is his categorical statement at the very first instance.
If suppose there is a gap, let us assume, or there is some time gap between adducing, then we can say after that. Same moment, within a few seconds, he has mentioned 5 and 6 were also armed. with
Maybe, my lords, he has forgotten their names and
Naturally,
and
it shows how naturally he's deposing.
the woman accused, then he says, accused number 5 and 6 was also armed with stick. The woman accused persons also assaulted with stick to deceased Sabu. It is in this context I am submitting that truthful, consistent evidence insofar as accused numbers 5 and 6 is.
What is the evidence of PW1 and PW4? Whether they have stated that.
Yes, they have stated that specifically, they, not specifically, my lords, an allegation that they assaulted from head to toe. That is the allegation against accused number 5 and 6. They assaulted with clubs from head to toe. PW1's evidence may kindly be perused at 98, page 98. A1, my lords, got it. Page 98. A1, A3 and A4 assaulting my husband by X. A2 assaulting with stone on the legs of my husband. A5 and A6 beating my husband with sticks. That is the evidence insofar as 5 and 6 is concerned by PW1. Now PW4 may kindly be perused. PW4. At page 111.
Yes.
A5 and A6 assaulted me by bamboo stick from head to toe.
What is the injury sustained by him?
Yeah.
The nature of injury sustained by PW4.
The nature of injuries are grievous, my lords. It's at page.
Page.
Exhibit P19 wound certificate.
P19.
Out. Page 52 of the paper book. He sustained about 19 external injuries. And about 2 fractures. Injury number 11 and 15 are grievous in nature and all other injuries are simple in nature.
How long they were in custody?
Noted entry, madam.
5 and 6. X-ray or this one is produced by the prosecution?
X-rays are
X-ray produced. PW4.
Pardon?
PW4
Oh, the X-rays produced.
produced. So it's a clear fracture.
Fracture.
Hmm. How long they're in custody?
It's not forthcoming from the judgment as well.
See, can't bifurcate the incident. Once their presence is there with, so difficult. You see. So continuing here. So once their presence is proved in the assault of deceased, then their presence, we can gather their presence in the assault to the assault made by PW4 also.
Yes.
So we can't bifurcate that they were not present in the, while assaulting to the deceased and they were present at, while assaulting to PW4 also.
My submission would be,
Hmm.
their very implication in the case is doubtful. So,
So many contusion injury, exhibit P19.
my lords, not in dispute that stone is also used in the incident by one of the accused. So contusions,
This much of.
exhibit P17. At page 45. Lords, there are (29) injuries.
Now what is the evidence of the doctor?
Lords, his evidence,
Incident about these injuries, whether these injuries could be caused by bamboo, MO 5 and 6. Any such opinion placed?
Lords, the evidence is
PW?
PW 16.
Yes, yes. Come to page 157, huh?
Yes, my lords.
Oh.
It's 146.
146.
143 starts.
Yes.
(148) is the relevant paragraph. Death was due to
Oh.
148, page
Yes, yes.
148.
148.
Death was due to hemorrhagic shock as a result of injuries sustained.
Now what about the weapon?
Yes, ma'am. I will be reading the next line. On the plain paper that is on page 4, I have noted all the anti-mortem injuries, which is in continuation of page number 3. I have received the requisition letter from ESP Vijaypur to conduct PM examination in form number 1 as per exhibit 15 and form number 2 as per exhibit 16. I issued PME report as per exhibit P17 and my signature identified as exhibit P17A. Now I see the weapons used in the assault whereby which anti-mortem injuries such as MO number 8, which are large in number, the injuries caused, and also by X and handle with X, other bleeding injuries.
So MO 8 is the bamboo stick, huh?
No, my lords, it has to be injury number 8, not MO 8. MO 8 is broken handle of the X.
I see the weapons used in the assault whereby which anti-mortem injuries such as
Must be injury number 8.
Blunt and rough object ಅಂತ ಹೇಳಿದ್ರು. Blunt and rough object. Sharp, blunt and rough object. The injuries could be caused by sharp, blunt and rough object. So in the wound certificate. Wound certificate and ಹಂಗೆ ಹೇಳಿದ್ರು.
Exhibit P19.
19.
52. 52.
So come to your cross examination. Doctor 150.
150.
Injury number 6 and injury number.
It is true that injury number 8, vertically placed stab injury. It is false to suggest that punctured wound would be caused only by sharp pointed weapon. It is true that contused laceration possible hard blunt surface. I further say injury number 1 found on the forehead of the deceased, and also injury number 2 refers to head injury. Similarly, injury number 3 head injury, and similarly injury number 5 caused to head. Similarly, injury number 6, 7 and also injury number 8. It's true that head injuries which are shown as above as simple in nature. It's true that in all the head injuries, skull are intact. Injury number 23 is fracture displacement and also shown internal injury, fracture ribs on posterior side. I further clarified injury number 23 is external injury, but false to say that injury number 23 is internal injury. I have not shown type of fracture to injury number 23. The crush injuries will be possible to body by MO3 and MO number 7 stone boulders. It is true that stones heavily thrown on bodies other than crush injuries are not possible. Under the head of thorax on page number 2, the fracture of ribs are internal injuries, and I have not shown type of fracture. I further clarified that injury number 29 is an external injury and correspond to fracture ribs on left posterior side. The right hand injuries are 12 to 15. It's true they are not on vital parts of the body. It's false to suggest that vital injuries are meager injuries. It's true that I have not mentioned dimension to injury number 14 because it being multiple irregularly overlapping. It's true that injury number 16 is left arm injury, and similarly injury number 17, 18, 19 and 20 are lower limb injuries. It's true that 12 to 18 are simple in nature. It's false to suggest that except the fractures, all other injuries are simple in nature. Bone deep injuries are injuries number 1, 3, 5, 6, 7, 8, 16, 20, 21, 22, 23, 26, 27 and 28. It's true that bone deep injuries are, that is injuries so and so, are with bones intact. It's false to suggest that the deep bone injuries are not possible by MOs number 8, MO number 21 and MO number 29. It's false to suggest that by weapons MOs 8, 21 and 29 used in
21 and 29 are bamboo sticks.
the handles of axes.
29.
How the axe with handle? It's an axe with handle.
No. MO.
Axe with handle. Oh.
Now what about this?
21 is also an axe with
27 and one
Twen-
more?
27 and 24.
24 and 27.
How?
Any such suggestion in respect of 24 and 27?
No, no.
No. Opinion cross model. ಯಾರು ಕಂಡಕ್ಟ್ ಮಾಡಿದ ಟ್ರಯಲ್
Mr. MC.
ನಾಟ್ ಕಂಡಕ್ಟೆಡ್ ನೀವು ಮಾಡ್ತೀರಲ್ವಾ? Also,
Yes,
ನೀವು
but,
ಟ್ರಯಲ್ ಮಾಡಿ
but I am not conducted.
you also ಟ್ರಯಲ್ ಮಾಡ್ತೀರಿ?
Yes, yes.
So one more part appeal is, part heard appeal is there.
Yes.
Kalaburagi. So we will, may take up your appeal on Wednesday
Please.
for further argument, next Wednesday.
Yes, ma'am.
It's on 13th,
Obliged.
12. For further argument. So inquest ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಇದೆಯಾ ನೋಡಿ, ಹುಡುಕಿ ಏನಾದ್ರೂ ಇದೆಯಾ ಅಂತ, ಅವರಿಬ್ರದ್ದು ಪ್ರೆಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಏನಾದ್ರು.
5 and 6.
Just go through.
Prima facie, that you are against a wall.
Madam, ಸ್ವಲ್ಪ ಎಮೋ ಸರ್ ನೋಡ್ಕೊಡಿ ಮೇಡಮ್, ಅವ್ರು ಎಂದ ಅರೆಸ್ಟ್ ಆಗ್ಯಾರ ಏನ್ ಸುದ್ದಿ, ಎಷ್ಟು ದಟ್ ಈಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿದ್ರೆ ಸಿಗ್ತಾವ, ಸ್ವಲ್ಪ ನೋಡ್ಕೊ.
ಎಕ್ಸಾಮಿನೇಷನ್ 323 ನಡೆದಂಗ ನಡೆಸ್ಯಾರ. ಸಜೆಷನ್ಸ್ ಮಾಡಲ್ಲ 24 ಅಮೌಂಟ್ 24 and 25. ಈಗ ಏನ್ ಬಿಡ್ರಿ ಪಾಪ. They executed a bond before the SHO, before the police?
No, my lord, only notices are served upon me, my lord.
Oh.
That is the one, because
Or
that.
there is no such direction that a bond has to be executed before the jurisdictional police?
No, my lord. Here is a case, my lord, wherein the respondent number 2 is completely bedridden, my lord. Notice was served upon her son, my lord.
Hmm.
Thereafter, my lord, so yesterday it was served. Yesterday around morning.
Yes. Huh? Okay.
Executed. Available warrant executed. Available warrant executed by serving them. Then he must have executed a bond before the jurisdictional police.
In the room. Date of execution of the bond. Continuance of the available warrant does not arise. So and so appears for R2 and submits that they would take a stand in writing by the next date. Relist on 18. Why? Huh? Mahakumbha. Huh? If everybody go, what will happen now? Mallikarjuna is gone.
Apology.
18. Relist on? On relist on? Relist on 18. 19.
Prashant Ojantri,
But I'm for the petitioners, my lord.
Nim matter bandilva, madam. That's over. Let it 5 minutes. Let that other come pass over. Erdu ಒಂದೇ ಸತಿ ತಗೊಳ್ಳಿ.
Ganesh Kalaburagi,
The letter sent to me, my lord, I have asked in the morning.
ಕೊಡಿ.
The honorable court asked to, what is the stand? Insofar as, my lord, the possession is concerned, it is in the letter, as per the letter, my lord, possession is not taken. My lord, insofar as the payment is concerned, my lord, there are the records, my lord. In the letter, it was not whispered. But the records, my lord, it is not deposited. It was sent by the court. Since he has received the notice of the award.
Let them file affidavit. Taking note of the order of 22/1/2025 as well as communication addressed to the PGA dated 4/2/2025. The Special Land Acquisition Officer KIDB Kalaburagi to file an affidavit adverting to the aspects the subject matter of the order dated 22/1/2025 by the next date. Affidavit to be filed along with relevant records before the relevant records relating to the payment, taking of possession, etc. Relist on
Right. Friday.
Well. This is well.
Please, Jatin sir.
Where is your senior? Correct. ಯಾವಾಗ್ಲೂ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಹೇಳುವಾಗ ಐದರ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಮುಂದೆ ಅಥವಾ ಬೇರೆ ಲೋವರ್ ಅಥಾರಿಟಿ ಮುಂದೆ ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಾರ್ದು. I am just telling you. So you should learn that when you come before the highest court, you should say that either he is not available, because it doesn't look nice that instead of giving preference to the division bench, he is there. That may be a fact. So presentation must be that he is not available. So we'll have it some other day. We'll have it some other day. Relist the matter on short date. 11th.
ನೀವು ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ನೀವೇ ಮಾಡ್ಬೇಕು ಅವತ್ತು 11th ಗೆ ನೀವೇ ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಏನಂತ.
Yes, next.
Number 34, Nandkishore Booth, connected. Mahadesh Resideswar.
Just a minute. Now, when the initial incident caused by accused number 1/6/2016. Thereafter, next, after 1 month. Rented house. That is after 1 month. So 2016, 17, probably 172. So now thereafter accused number 2 took this file. It's on 15 August, 15/8. 15/8/2016. Yes, yes. Now the subsequent incident by P accused number 2 is on 15/8. Yes. Just a minute. Complaint lodged? 23/8, 2016. So on that day itself, on 15/8/2016 itself, the boy returned, this PW1.
Yes.
He returned. So some delay that is on from 15/8 to 23/8. Some 8
1
days
week,
delay.
1 week.
So for that delay, he must have explained. ಏನಂತ reason ಹೇಳಿದಾರೆ. Just a minute. Now, thereafter, after lodging of complaint, what is the medical evidence?
Yes. 9.
PW9. Medical officer.
Page number 94, he has narrated.
Hmm.
Page
94. End of the list.
Malla, your conduct, you are a teacher.
He has not complained to anybody.
ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಸಭ್ಯವಾಗಿ ನೀವು ಎಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ ಅವನನ್ನು? ಹ್ಮ್ ಹ್ಮ್ confined and you committed the act. Out of fear, he was unable to inform. Out of fear, he has stated that out of fear and not informed the matter to in my house anta. He has stated, though he was suffering uneasy. Huh? And further, he also stated that he was unable to have food and he was facing difficulty in passing urine. At that point in time, he revealed. Thereafter, he revealed.
So my first ground is that. So in order to prove the age of the victim, they are not too much. Because particularly also examined the age.
Just one.
PW 11, huh?
Yes, my lord.
Huh,
99 page number.
99. Oh.
Yes, ma'am.
Harrier stated 162,000. Huh? Huh. 162,006.
The entry in respect of victim was made in admission.
Huh.
So, my lord, when he has taken admission, at that time he was 5 years.
5 year?
Yes.
Ah, so.
He was even not
Wow.
completed 6 years.
Hmm. Hmm.
And Lord, that registrar is also not known. And
So the boy, he was aged about 5 years, 7 months, at the time of admission.
that was not correct. They are not.
ಹೌದು 18/10/2000 ಆದ್ರೆ ಅವಾಗ 5 years 7 months ಆಗುತ್ತೆ ಅಂತ ನೀವ್ ಹೇಳೋದು.
ಹಾ.
ಸ್ಟ್ರಿಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ಸ್ 6 ವರ್ಷ ಆದ ನಂತರನೇ ಸ್ಕೂಲ್ ತಗೊಳ್ಳುದಂತ ಏನಿಲ್ಲ. ವೆದರ್ ಎನಿ ಸಚ್ ಹಾರ್ಡ್ ಅಂಡ್ ಫಾಸ್ಟ್ ರೂಲ್ 5 years ಎಬೋ ತಗೊಳ್ತಾರೆ ಈಗ ಎಲ್ಲ ಕಾಲೇಜಲ್ಲಿ 5 years ಎಬೋ ಸ್ಕೂಲಲ್ಲಿ ತಗೊಳ್ತಾರೆ. ಫಾಸ್ಟ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್.
UC first year. UC first year, not second year. Ah, then.
Hmm. That is one aspect, huh? Hmm.
But counsel, when you're arguing a POCSO case, must you not go directly to the rule pertaining to date of birth? Which is the rule? Which is the rule? Which is the rule? I'm asking a simple question. When you're doing a POCSO case and you're arguing for the accused for the determination of age, which is the rule which provides what document is to be provided? Correct. Which read that rule and tell us. You must argue in reference to that rule, how it is not followed or followed, you have to argue, isn't it? Yeah.
Initially, it was Rule 12, my lords. And thereafter it is amendment 1994.
15 ಅಲ್ಲಿ
12.
ಅದೇ
12, Rule 12.
15 ಅಲ್ಲಿ amendment.
Yes, my lords. That has been amended in 2015. So, brother?
A part-time teacher or it's a regular teacher appointed by government? The government employee, huh? Government employee. Huh? Your client, accused number 1. Menace to the society, ಇವರನ್ನೆಲ್ಲ ಟೀಚರ್ ಕಟ್ಟಿಕೊಂಡಿದ್ರೆ ಏನ್ರಿ ಆಗ?
Complaint ಓದಕ್ಕೂ ಅಸಹ್ಯ ಅನ್ಸುತ್ತೆ. Apparently, while reading.
Why explained such a way in this evidence, PW1? What Supreme Court judge ಏನ್ ಹೇಳಿದ್ದಾರೆ? P77 is punishable up to life.
Yes,
Up to life.
life.
377 punishable up to life imprisonment. We'll keep this appeal. You file a state appeal. Will
Yes.
enhance the sentence.
Yes,
The brutal act by these
Yes.
accused, they're horrifying the tale of brutality. No gender discrimination, nothing. For that boy, you being a student, teacher. Huh? ಏನಕ್ಕೆ ಮಿನಿಮಮ್ 10 ಇವರಿಗೆ? ಮತ್ತೊಮ್ಮೆ ಬಂದು ಇಂಥದನ್ನು ಮಾಡ್ಲಿಕ್ಕ? This appeal will be convicted accused number 1 and 2. Appeal by the convicted accused number 1 and 2 directed against the judgment of conviction and order of sentence passed in special case bracketally POCSO number 55 of 2016 dated 6/7/2019 by the second additional sessions judge at Kalaburagi, whereby the learned special judge hereinafter learned special judge referred to as learned special judge, whereby the learned special judge convicted the accused appellants for the offence punishable under section 377 and 506 of IPC and under section 6 of POCSO Act, 6 of Protection of Children from Sexual Offence Act 2012, full short. The accused 377, 506 and section 323 also convicted, alva? 323. 323 also. Full short. The and sentenced and sentenced them to undergo rigorous imprisonment for life and a fine of ₹1 lakh for the offence punishable under section 377 of IPC and section 6 of POCSO Act 2012 in default to pay fine, they shall undergo imprisonment for a period of 2 years. Same sentence, alva, for both accused and party. For the accused also sentenced to undergo rigorous imprisonment for 2 years and to pay fine of rupees 5,000 for the offence punishable under section 506 of IPC, and in default of pay of fine, shall undergo imprisonment for a period of 6 months. 6 months. 6 months. Further, the accused also sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 1 lakh for the offence punishable under section. First listen. Further, separate sentence awarded. Thank you, sir. Yes. Further, it is directed that both the sentence, all the sentences shall run concurrently. For sure. All the substantive sentence shall run concurrently. Next, the abridged facts of the case are as under. The PW1 victim in this case is, victim in this case lodged the complaint before the respondent police alleging that the accused number 1 was working as a physical education teacher in Basaveshwara Higher Primary School. He also running a stationery shop in Bajaj Market, where accused number 2 was visiting frequently. Full shop. When the accused was studying in 4th standard, he has taken tuition for mathematics and science subjects from accused number 1. Full shop. Thereafter, while the PW1 studying in 10th standard, in Bethany School, the accused number 1 identified him and expressed that he has given by making a conversation that he has given tuition to him and invited PW1 to his shop. Full shop. Later, in the month of June 2016, when PW1 had been to the shop of accused number 1, he invited him to go to Hyderabad to purchase materials. Also, to invited him invited him to go to Hyderabad to purchase materials. Full shop. On the next day, that is at about next day, accordingly, they both went to, both had been to Hyderabad, Begum Bazaar, and purchased the stationaries. Full shop. Thereafter, when they came back to lodge, they had meals, and both of them were slept in the same room. Full shop. During night time, accused number 1 expressed his desire to have carnal intercourse with the PW1, and thereby he made an attempt of such act by removing clothes of the dress of the victim PW1. Though PW1 resisted for the same and went out from the room, later, when he came back to the room, came back to the room, later he came back to the room and the accused continued such act with him. On the next day, later in the night hours, late night hours, ಆಗ್ತಾ ಇದೆಯಾ? Later in the night hours, later in the late night hours, the accused once again made an attempt to have physical relation with the PW1 and thereby forcibly removed his shirt and removed his dress and had carnal intercourse with him. Full stop. Further, the accused number 1 threatened the victim not to disclose the same to anybody. Full stop. After 1 month, subsequently after 1 month, when PW1 went to the shop of accused number 1, he once again took PW1 to his house, and at about 12 noon, he undressed PW1 and had carnal intercourse with him. Full stop. Out of fear, he did not inform the same to anybody. Later, in the month of August 2016, on the day of Independence Day, after flag hosting in the office of Tahsildar at about 9:30 a.m., when PW1 went to the shop of accused number 1, accused number 1, the accused number 2 and other friends of accused number 1 were present in the said shop. Full shop. All of them have decided to go to Kalaburagi Mukta Theatre to watch a movie. Full show. At about 2 p.m., after watching movie, they left Kalaburagi, and while proceedings towards they left Chittapur, and while proceedings towards Kalaburagi on motorbike, on the way, accused number 1, CW9 and 10 consumed alcohol, and all of them reached Kalaburagi. Since it was late, they did not get tickets, and then they went to Miraj Theatre. Full shop. However, accused number 1 and his friends decided that they will not get the tickets and hence to have the meals at Samdan Hotel after taking liquor. Full shop. After having the meals, at about 7 or 8 p.m., the 8 p.m., PW1 was at Tengli Cross when PW1 and CW8 traveling in the motorbike, PW8 stopped the bike, and when they were waiting for arrival of remaining persons, accused number 2 came there on his bike and asked CW11 to get down from the bike and made him to sit on his bike. Without waiting for others, accused number 2 started riding the bike. On the way, without going towards Chittapura, he took the victim to a land at Malakad Road, and there he forced the victim PW1 to smoke cigarette, and thereafter he assaulted him and threatened him that threatened him that he knows what accused number one did to him and at Hyderabad and in his house, and thereby forced him to have carnal intercourse, thereby removed his shirt and pant and had carnal intercourse with him. Full stop. Since accused number two also threatened not to disclose the said aspect to anybody, comma, the PW1 remained silent, full stop. After 2 days after the incident, comma, after 2 days, he was unable to have food and was unable to pass urine. As such, he informed the same, he revealed the said aspect to his parents, and thereby PW, who lodged the complaint, thereby, comma, thereby, comma, PW1 lodged the complaint, thereby he lodged the complaint before,
PW 13.
complaint before PW 13 as per exhibit P1, full stop. On the strength of exhibit P1, comma, PW 13 has registered the FIR in crime number, comma, 87 bar 2000, crime number 87 of 2016 dated 23/8/2016 for the offence punishable under section 323, 504, 506, 377, with 34 of IPC and section 4 and 6 of Protection of Children from Sexual Offence Act, POCSO Act, against the accused, full stop, against accused. Thereafter, comma, the PW 13 conducted the further investigation by arresting the accused and also based on their voluntary statement, and also after recording their voluntary statement, comma, the motor bike which
The FIR is marked as exhibit P22.
And thereafter recovered the motor bikes which used for the commission of the crime,
Which belongs to
commission
A1.
of the crime, and also drawing the spot mahazar at exhibit P7 and P7 and the other relevant mahazars, and recording the statement of other witnesses, comma, laid the charge sheet before the special court, comma, PW, after a detailed investigation, PW 12 has laid the charge sheet before the special court for the offence punishable under section 323, 504, 506, 323, 506,
Yes.
377 read with the 34 of IPC and section 4 and 6 of POCSO Act 2012, full stop, 2012. The learned session judge, after securing the presence of the accused, comma, framed the charges for the said offences and read over to the accused. However, the accused denied the charges and claimed to be tried. Full stop. The next, in order to prove the charges leveled against the accused, comma, before the special court, comma, the prosecution in total examined 13 witnesses as PW 1 to 13. So also got marked 22 documents as exhibit P1 to P22. And got identified 2 material objects, MO1 and MO2. Full stop. Full stop. After completion of the prosecution evidence, comma, the incriminating evidence of the material witness read over to the accused as per the provisions of section 313 CRPC. However, the accused denied the same. The defense of the accused is a total denial and that of false implication. Full stop. The next, after assessment of the oral and documentary evidence, comma, the learned special judge has convicted the accused for the charges for the offense they were charged and sentenced them as stated supra. He said the judgment is challenged by both the accused in this appeal. Both the accused by filing these two appeals. That is more specifically the criminal appeal number 20091 of 2019 filed by accused number 1 and criminal appeal number 200152 of 2019 filed by accused number 2. Accused number 2, full stop. We have heard the we have heard learned for the Shri so and so this Rakpalli, Mantesh and Nandakeshwar for the appellants in both the appeals and the learned additional SPP Shri Patil. Yeah, it is the contention of the full stop. The counsel for the appellant, counsel for the appellants in both the appeals, submits vehemently argued that the trial court erred while convicting the accused for the offence punishable under the provisions of POCSO Act, so also under section 377 of IPC without appreciating the evidence available on record in a right perspective. Full stop. They would contend that the prosecution has failed to prove the age of the victim by PW1 by placing any authenticated document, nor the prosecution has made any attempt to examine, attempt to conduct the radiological examination or falsification test of the accused by victim to determine his age that he was minor at the time of incident. Full stop. The learned session judge solely relying on exhibit P17, the age certificate issued by PW9, the headmaster, PW9, the headmaster,
11.
PW11, the
Yes.
headmasters, convicted the accused for the offence, under the provisions of POCSO Act, full stop. They would further contend that on perusal of the evidence of PW1, the victim, there is an inordinate delay of 8 days in lodging the complaint, even after the last alleged incident. Full stop. As a alleged incident. However, according to PW1, the initial incident set to have caused on 1/6/2016 and the 16 and the complaint was lodged on 23/8/2016. 23/8/2016. In such circumstance, the version of PW1 cannot be believed. Full stop. They also would contend that the PW4 being the uncle, uncle of the victim, was involved in is an practicing advocate, so also involved in local politics, and there was a quarrel between the accused, between himself and accused prior to the incident. As such, he had falsely implicated. He has falsely implicated these accused in the incident. Full stop. In the incident, full stop. They would also contend that the medical content that on perusal of the evidence of the doctor, that is PW, Dr. PW9, the PW9, there is no such injuries or signs of signs of anal intercourse forthcoming in the report issued by PW9 as per exhibit P13, nor PW9 as stated to that effect, to stated to that effect, full stop, no, stated to that effect, full stop. What is your submission? What is your submission? PW2. ಯಾವ್ದ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಓದ್ ದಿ ಎಕ್ಸಿಬಿಟ್
ಇದೆ ಸರ್.
ಹಾ
ಇದೆ ಸರ್.
ಏನಿಲ್ಲ
12 last parameter. Balance.
ಇಲ್ಲ ರೀ ಹೌದ್ರಿ ಎಷ್ಟು ವಾಟ್ ಈಸ್ ದ ಇಂಗ್ರೀಡಿಯಂಟ್ ಟು ಎನಿ ಎಕ್ಸ್ಟೆಂಟ್ attempt to ಸಾಕ್ರಿ to any extent section 4 and 6 what is aggravated penalty
5.
ಒಂದು ನಿಮಿಷ ಇಲ್ಲದೆ read section 3 of POCSO. Read section 3 of POCSO. Penetrative sexual assault. Penetrative sexual assault. If he penetrates his penis to any extent, the vagina, mouth, urethra, or anus of a child to any extent, you made attempt. Not attempt ಅಲ್ಲ ರೀ, attempt in the sense ಏನ್ ಹೇಳಿದ್ದಾರೆ? Read the evidence, page number 12. ಪೇಜ್ 12 ಅಲ್ಲಿ ಓದಿ ಎವಿಡೆನ್ಸ್. ಆಯ್ತು. ನನ್ನ ಕಪಾಲಕ್ಕೆ ಜೋರಾಗಿ ಹೊಡೆದು ಯೋಗೀಶ್ ಮಾಸ್ಟರ್ PW accused number 2 ಅವರ ಅಂಗಡಿಯಲ್ಲಿ ಮತ್ತು ಹೈದರಾಬಾದ್ನಲ್ಲಿ ಏನು ಮಾಡಿದ್ದಾನೆ ಎಲ್ಲ ನನಗೆ ಹೇಳಿದ್ದಾನೆ. ಸುಮ್ಮನೆ ಕೂಡುವಂತ ಅವನ ಪ್ಯಾಂಟ್ ಬಿಚ್ಚಿ ಅವನ ಅಂಡರ್ವೇರ್ ಕೆಳಗಿರಿಸಿ ಅವನ ಹೊರಗೆ ತೆಗೆದು ನನಗೆ ಕೆಳಗಡೆ ಕುಡಿ ಒಂದೆರಡು ಬಾರಿ ಚುರುಕಿ ಹೊರಗೆ ತೆಗೆದನು. ಮತ್ತೆ ಪ್ಯಾಂಟ್ ಮತ್ತು ಅಂಡರ್ವೇರ್ ಬಿಚ್ಚಿ ಬೋರ್ಲಾಗಿ ಮಲಗಿಸಿ ಜಬರ್ದಸ್ತಿಯಿಂದ ಒತ್ತಲು. ವಾಟ್ ಎಲ್ಸ್ ರಿಕ್ವೈರ್ಡ್? Or of penetrative sexual assault, section 3. Definition. Yes. What section 3 says? He penetrates his penis to any extent. Any extent. ಹೆಂಗೆ 7 years? 4 ಗೆ conviction.
Before 2019 November, because the incident happened in 2016.
When the incident was?
Date 2016.
2019 ಅಲ್ಲಿ announce ಆಗೋದು, 19 ಅಲ್ಲಿ announce ಆಗೋದು. ಏನ್ ಹೇಳಿದೆ? PW9, in such, PW9. 9. Further, the PW, further the evidence of PW2 with the father of the victim, and PW3 and 4 are the close relatives of the victim, cannot be considered, cannot be taken into consideration, since they are the partition witness to the incident, full stop. With this submission, they praise to allow the appeal, full stop. Per contra, the learned session, per contra, the learned additional SPP would submit that, the learned session judge, after meticulously examining the evidence available on record, convicted the accused, the said judgment does not call for any interference. You would submit that the learned session judge appreciated the evidence elaborately, and the PW1, the victim boy, has categorically stated in his evidence above, that on initially the accused number 1 has committed the incident on 1/6/2016, and subsequently he repeated the said act after 1 month, and later on 15/8/2016, the accused number 2 also committed a anal sexual intercourse with the PW1, Though there is a delay in lodging complaint, the said delay is properly explained by PW1 for that PW1 that due to the threat foisted by the accused, he failed to lodge any complaint, full stop. He would further contend that the doctor who examined the victim, that is PW9 in his evidence categorically stated that there is no possibility of ruling out the anal sexual intercourse to the victim, full stop. Victim. The prosecution, as such, the oral testimony of PW1 clearly corroborates to the medical evidence,
Yes.
Of PW9. Further, the prosecution also proved the age of the victim, that he was minor at the time of incident, by placing the evidence of PW11, the headmistress, and the document exhibit P17, the age certificate age certificate of the victim, which clearly depicts that the victim was aged below 16 years at the time of incident. Full stop. You would also submit that PW2 and 3, PW2 to 4 are the hearsay witness to the incident, before whom the victim has narrated the incident, and thereafter they lodged the complaint, full stop. Lodged the complaint. In such circumstance, there is no reason to discard the evidence of victim PW1, so also the evidence of PW2 to 4. Accordingly, the learned session judge has properly appreciated the evidence on record and convicted the accused for the charges leveled against them. Hence, interference does not call for in the impugned judgment. Accordingly, he prays to dismiss the appeal. Full stop. Having heard the learned counsel for the respective parties, so also having perused the entire evidence and documents made available before us, the points that would arise for our consideration, whether the judgment under this appeal suffers from any perversity or illegality. Number 2, whether the learned session judge is justified in convicting the appellants for the offense punishable under section 377, 323, so also of IPC, so also section 4 and 6 of POCSO. Section 4 of, Section 4 of POCSO Act, 4 of POCSO Act, full stop. Next, the POCSO Act, in order to prove, full stop, in order to prove the charges leveled against accused, comma, against the accused, comma, the prosecution, in this case, comma, the prosecution has predominantly relied the evidence of PW1, the victim, victim, and so also the evidence of PW224, PW224 were the relative father and close relative, father and relative of the relative of PW1, So also the medical evidence of PW9, the doctor, and the evidence of PW11 who issued the age certificate of the victim. Full stop. On careful analysis of the evidence of PW1, the victim, he has categorically deposed before the court that in the year 2016, though accused number one asked him to visit his shop and by introducing himself that he gave tuition to him in the while he was studying at fourth and fifth standard, and thereafter in the month of June 2016, he took PW1 to Hyderabad and in the guise of purchasing materials for his shop. After such purchase, the accused number one committed forcible anal intercourse to PW1 in the room. Full stop. Later, after 1 month, the accused number one also committed anal intercourse to him in his house. Full stop. After said act, he threatened PW1 not to disclose the same to anybody. Full stop. PW1 further deposed that by taking undue advantage of the act committed by accused number one, and the accused number one having disclosed the same to accused number two, accused number two also committed anal intercourse with him on 15/8/2016 in the field at Malkad Road.
As per the exhibit B.
Malkad Road, full stop, Malkad Road. Malkad Road. The said evidence, full stop, Malkad Road. The said evidence of PW1 clearly supported by the evidence of PW3, who is the cousin of
PW1.
PW1. According to PW3, on 15/8/2013, 15/8/2016, the accused, the PW1 was disclosed him about the act committed by the accused number two, and so also accused number one. Full stop. The PW2 father of the victim, and PW4, the uncle of the victim, also reiterated the evidence of PW1 and 3. Full stop. On careful examination of all these witnesses, examination of the evidence of PW1 to 4, though there is a delay in lodging the complaint, there is no reason to discard their evidence discard their evidence as far as the act committed by the as per the as far as the act of carnal intercourse committed by the accused to PW1, full stop, PW1 to PW1 to full stop, in order to prove the age of the victim, that the victim was minor at the time of incident, the prosecution has relied the age certificate issued by PW11, the headmistress of the school, which the headmistress of primary school, higher primary school Chittapura, where the PW1 studied is studied, full stop. On perusal of exhibit P17, exhibit P17, the date of birth of the PW1 is mentioned 1810-2000, full stop. The according to PW11, the said certificate issued by
Page number
him.
99.
Page
number 99.
Issued by him based on the request made by the IO, request made by the ಇದ್ಯಾವುದು ಕೇಳಿದ್ದೀರಾ ಅದನ್ನಾದರೂ? On 1/6/2006, 16 ಅಲ್ಲಲ್ಲ, made by request made by the IO. Request made by the IO, full stop, IO. On full stop. Further PW11 as 11 has stated that 11 further in the evidence of PW11, it is forthcoming 11. It is stated that the trial court has perused through the original admission register brought by the witness according to which the date of birth victim is 1810-2000. Full stop. However, the original register is returned to the witness. Full stop. As such, it is clear that the admission register is not marked in evidence. Moreover, the exhibit P17, the age certificate issued based on the register maintained, based on the admission register maintained in the school, full stop, maintained in the school. Further, the doctor PW9 who examined the victim also has not stated about the age of the victim, full stop. Admittedly, the prosecution, either PW9 or the PW9 has not referred PW1 either to radiologist or dentist to determine the age of the victim, full stop, age of the victim, full stop. The prosecution, full stop. It is forthcoming in the evidence of PW1 that he has completed his matriculation, that is 10th standard examination, 10th standard, full stop. In such circumstance, the prosecution also failed to place the matriculation certificate issued by the school authority to prove the age of the victim. Admittedly, there is no such authenticated document, that is like birth certificate is placed by the prosecution in his evidence or in the charge sheet papers, charge sheet materials, full stop. In such circumstance, comma, in such circumstance, except exhibit P17, the birth certificate issued by PW11, comma, absolutely no other authenticated documents placed by the prosecution to prove the age of the victim that he was minor at the time of incident, minor at the time of incident. Full stop. The minor at the time of incident. According to him, according to PW1, comma, he completed his 12th standard,
11.
completed its PUC. Second year PUC. ಎಲ್ಲಿದೆ ಅದು ಇದೆಯಾ? It is forthcoming in the evidence
PU1
of
ಅಂತ.
PW1. In the evidence of PW1, comma, it is forthcoming that he was studying second PUC at the time of deposing his evidence. Yes. Evidence. Evidence in such circumstance, comma, in such circumstance, comma, without any such authenticated document, comma, authenticated document as stipulated by this court and the honorable apex court in pattern of judgments, comma, the age, comma, the age of the first authenticated document, comma, the coordinate bench of this court in criminal appeal 200109 of 2014 dated 5/11/2024 held regarding determination of age of the victim at paragraph number 40 and 41. 40 and 41. Full stop. 41, full stop. The honorable, full stop. Further, the honorable apex court in the case of Yuva Prakash, in the case of Yuva Prakash versus state represented by Inspector of Police, police reported in 2023 AR SC 3525.
Seek apology.
3525.
I may be permitted to file additional document pertains to 10th mark. Okay, I tell it.
3525.
There's no bar at all.
25 held in para 12, para 12 complete madbidi, para 12 and 12, 13, 14 alva, 12 to 14 alva. Correct. 12 to 16 happen. Para 12 to 16. 12 to 94(2) of JJ Act mentioned ಮಾಡಿದ್ದಾರೆ. Para 12 to 16. Para 12 to 16 as under full stop, as under. Hence, comma, as under. Hence, on applying the principle, applying the findings of the honorable apex court in the above judgments to the fact and circumstance of this case, comma, we are of the consider view that the prosecution has failed to place any such authenticated document to prove the age of the victim, that he was minor at the time of incident, full stop, incident, full stop. Incident. In such circumstance, comma, in such circumstance, though the prosecution has successfully proved the act of carnal sexual intercourse committed by the accused on PW1, comma, PW1, the said act of accused squarely falls within the ambit of section 377 of IPC instead of section 4 of POCSO Act, 4 of POCSO Act, full stop. So 4 of POCSO Act. It is on careful perusal of section 4 of 3, section 3 and section, in order to attract the provisions of section 3 and 4 of POCSO Act, comma, it is the accused must be a child, the victim must be a child and child as defined in section 2 subclause 2 subclause 2 subclause D of the act, that is below the age of 18 years, below the age of 18 years, 18 years. Hence, below the age of 18 years, full stop. 18 years. In 18 years, on 18 years, full stop. Even on careful perusal of the impugned judgment passed by the session court, the learned session judge has also failed to give such finding in respect of the age of the victim, that he was minor at the time of incident, full stop. Hence, in our view, the conviction imposed by the trial conviction and sentence imposed by the session court for the offense under section 4 of POCSO Act is required to be interfered, and it's liable to be set aside. However, liable to be set aside. However, since on perusal, based on the evidence of on perusal of the evidence of PW1, the victim, so also the evidence of PW 2 to 4 and PW 90 doctor, we are of the view that the prosecution has successfully established the guilt of accused for the offense 377 of IPC. 377 and section 323 kuda koಟ್ಟಿದ್ದಾರೆ.
Yes, brother.
And section 323 of IPC. Full stop. The full stop. 320 full stop IPC. However, the learned session judges imposed conviction for the
And also 506 minutes. 506 minutes.
Conviction Act 506.
Okay.
323 and 506 sometimes. The learned session judges sentenced the accused for life imprisonment for the offense punishable under section 377 377 and 6 of POCSO Act. So also say 377 and 6 of POCSO Act. Both the accused, 77 and 6 of POCSO Act, full stop, POCSO Act. Hence, POCSO Act, full stop. The punishment awarded section punishment defined in section 37 for the offense 377 IPC is imprisonment. The imprisonment for life, or with the imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. In the case on hand, both the accused are in custody, incarceration for a period of 8 years.
8
years. Incarceration for a period of 8 years. 8 years, 6 months. 8 year, 6 months as on date. 8 year, 6 months as on date. In such circumstance, we are of the view that suffice to sentence the accused for the period they were already undergone for the offense punishable under section 377 of IPC by imposing reasonable fine amount. Full stop. Reasonable fine amount. In that view of the matter, the interference in the impugned judgment is called for, and accordingly we answer the point raised above point raised above, that is point number one in the negative, and point number two, partly affirmative, and proceed to pass the following order. The criminal appeals are allowed in part. The judgment of conviction and order of sentence passed in SC number by the session court, so and so, SC number, special case 55 of 2016, dated 6/7/2019, passed by second additional session judge at Kalaburagi, is set aside for the offense punishable under section 4 and 6 of POCSO Act. 4 and 6 of POCSO Act. Full stop. 4 and 6 of POCSO Act. Next, 6 of the accused number 1 and 2 are the appellant accused are acquitted for the offense punishable under section 4 and 6 of POCSO Act. POCSO Act. Full stop. The the 6 and 4 respectively. 6 and 4 respectively. Next, the conviction and sentence imposed by the special judge for the offense 377 of IPC is modified. By sentencing the accused for the period they were already undergone, that is 8 years, 6 months. 8 years. ಲೆಕ್ಕ ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್, ಇಲ್ಲದ್ರಲ್ಲಿ ಬಿಡಲ್ಲ. ಆಗಿದೆ 8 years, 6 months. 8 years, 6 months and 8 years, 6 months and they shall pay fine of rupees. ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ? ಸಾಕಾಗಲಿಲ್ಲ. PW1 ಗೆ ಎಷ್ಟು ಕೊಡ್ತೀರಿ?
3 lakhs.
ತಿರ್ಗಾ ಹಂಗೆ ಎಲ್ಲ ಬಾರ್ಗೇನ್ ಇಲ್ಲ.
So what? In fact, they have to be in jail for long life, as far as the seeing exhibit P1.
1 lakh each.
Yes.
1 lakh each.
Yes.
ಕೊಡಿ 1 lakh each ಕೊಡಿ. ಬರ್ಲಿ ಅವ್ರ ಹೊರಗಡೆ. 1 lakh each. Failing 1 lakh each. In default of payment of fine, they shall undergo imprisonment for a period of simple imprisonment for a period of 2 years. 2 years. Full stop. The next 2 years. The conviction and sentence, the sentence imposed by the trial court for the offense punishable under section 323 alva. 323 and 506 alva. 506 are kept intact. Next, the if the accused either on deposit of the fine amount or undergoing the default sentence, the accused shall be released if they are not required in any other case. Next, if the accused are deposited the fine amount before the trial court, the learned session judge is directed to intimate the same to PW1 and disperse to him on due identification.
Yes.
Due identification. All the sentence shall run concurrent. ಒಂದು ಸೀದಾ ರಿಡಕ್ಷನ್ ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುದಲ್ಲ, ಮೆರಿಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ರಿಡಕ್ಷನ್ ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟು ಏನೋ ಆಯ್ತು ಸ್ವಾಮಿ ಕೊಟ್ಟು ಬಿಡಿ, ಅದಕ್ಕೆ ಎಷ್ಟು ಅಂಡರ್ಗೋನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳುದಲ್ಲ, ಮೆರಿಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ DB ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಎಲ್ಲವನ್ನು ಈಚ್ ಅಂಡ್ ಎವ್ರಿ ಪಾಯಿಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು.
Serial number 38 is a state appeal minutes. Thirty-eight.
13.
After my serial number
First,
60.
please. No, what my submission would be, minutes, if it is posted on 10th, I'll argue the matter. Because it's within 1 year, the lady was committed suicide. So it's a matter of 304B and section 106 and
Evidence
all.
ಇದೆಯಾ?
It is,
Evidence ಇದೆಯಾ?
yes.
ಆಯ್ತು ನೋಡೋಣ next ನೋಡೋಣ.
Please.
Okay.
Avinash.
May I submit one?
Just 1 minute, just,
Not the petitioners are,
just 1
what-
minute.
please,
Just 1 minute. We'll take the fresh matter and then I'll immediately take out.
please.
Mike on.
Please, sorry. Ink page 21, madam. Annex there A1,
Yes.
my name is found at serial number 25, ink page 23. Dr. Padmaraj. ವೈದ್ಯಾಧಿಕಾರರು ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಮಣ್ಣಳ್ಳಿ ಬೀದರ್ ಜಿಲ್ಲೆ. ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆ ಬೀದರ್ ಜಿಲ್ಲೆ.
Yes.
Then they have issued one
This
amended,
order-
sorry,
This order is passed on 17.
17, my lords, 22/7/2017. It was modified on 18/8/2017. Only in respect of designation as a Deputy Chief Medical Officer, Jilla Aspatre, Bidar. Bidar, so and so, your Kramasanke so and so, Padmaraj so and so, ವೈದ್ಯಾಧಿಕಾರರು ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಮುನ್ನಳ್ಳಿ ತಾಲೂಕು so and so, ಜಿಲ್ಲೆ ಬೀದರ್ ಇವರನ್ನು ಜಿಲ್ಲಾ
Deputy
ಆಸ್ಪತ್ರೆ
Medical Officer.
Deputy Chief Medical Officer,
Hmm.
DCM, on 18/8/2017, my lords. Now his date of birth is, my lord, I have produced the annexure A4, my lord, in page 35. Fifth July 66, a certificate of that SLC certificate I produced, man. To show that he is going to retire he's
When?
59 years old.
Going to retire when?
Now he's 59 years old. 60 years he is going. Then he has proved that his mother is 100% disabled, is visibly disabled, my lords. I have produced the medical certificate A5. Now the impugned order is passed. Inserting my name as I have deputed.
Yes.
The impugned order is produced at ink page 27, my lord, and is there A3. Ink page 27, my lord. May I read it?
Page?
27, 27. ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಸೇವೆಗೆ ಸೇರಿದ ಕೆಳಕಂಡ ವೈದ್ಯಾಧಿಕಾರಿಗಳು, ವೈದ್ಯರುಗಳು, ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಹಾಗೂ ಆಹಾರ ಸುರಕ್ಷತೆ ಮತ್ತು ಗುಣಮಟ್ಟ ಇಲಾಖೆ ಅಧೀನದಲ್ಲಿ ನಿಯೋಜನೆ ಮೇರೆಗೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಸದರಿಯವರುಗಳು ನಿಯೋಜನಾ ಅವಧಿಯು ಮುಕ್ತಾಯಗೊಂಡಿದ್ದು, ಪ್ರಸ್ತುತವೂ ಸಹ ಅದೇ ಹುದ್ದೆಗೆ ನಿಯೋಜನೆಯಲ್ಲಿ ಮುಂದುವರಿಯುವುದರಿಂದ ಇವರುಗಳ ನಿಯೋಜನೆಯನ್ನು ಈ ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ರದ್ದುಪಡಿಸಿ ಇವರ ಸೇವೆಯನ್ನು ಮಾತೃ ಇಲಾಖೆಗೆ ಹಿಂತಿರುಗಿಸಲಾಗಿದೆ. I was appointed by the first respondent, that is the Health and Family Welfare Department. I transferred to the same department, in the same department, District Hospital, Bidar. My name is included as deputed, serial number 63, my lord.
Now in terms of the order, you go back where according to them?
According to them, they have to go back to their parent department. My parent department, Family and Health Department. I'm working there only.
So now they only say you go back to the thing.
I'm working there only, their department only, the Family Health and Family Department only. I transfer to the Bidar Hospital, District Hospital.
Question of repatriation doesn't arise.
Doesn't arise, my lord.
Now what is your tenure?
Tenure, my lord, that deputation, my lords.
No.
Huh?
You are working as deputy CMO, isn't it?
Yes.
Deputy Chief Medical Officer.
Yes, ma'am.
Tenure is Group A, Group B, what is that?
2 years.
2 years.
And he is going to retire, my lord, in 2026. And 4/7/26 he is going to retire.
We can do one thing. Of course, we'll hear him. Now what, you have come directly, you had gone to the KT or directly?
KT, my lord, KT, they have not considered there, even though I stated, I explained this, but they are not ready to grant the interim order. Since I explained my blindness of my mother, she is already acquitted in the same home. Then she can't move in some other place if they are transferred to some other places. That is also explained.
No.
His mother is 100% blind. And she is going to retire. He is working there only in his parent department.
But in support of that argument, if you are to say that your mother is a dependent.
Yes, my lord.
Is there any relaxation for caregivers?
Yes, the transfer guidelines, there is a relaxation.
Clearly, of course.
Clause 7(1)
Page?
That guidelines I have. 1A and F, my lords, that is 1A is the going to retire and F is the guidelines.
Yes. So which is that guideline?
25/6/24, they have issued a new guidelines.
Page?
page I'll produce ಮಾಡ್ಲಿಲ್ಲ
ಇಲ್ವಾ?
ಇಲ್ಲ.
What is,
By mistake, while drafting this, my lord, I refer that by mistake, it is somewhere in
what does that
some
say?
other files, my lord, included.
What does that say?
So, my lord, if that is class 7A is, my lords, if he is going to retire within 2 years,
That's
he
what you're-
can't transfer. Is any independent so and so they are disabled and some medical reason,
Dependent.
7AF, my lord.
That is if the dependent is.
Yes, my lords.
That's a mobile and noted.
Yes. 25. 25/6. Twenty-four.
What about retirement? What does it say? You have to seek
If
for.
he is going to retire within 2 years, he is
So
going,
what does the guideline say?
guidelines,
For guideline for.
transfer
retirement.
7(1)A, my lord, for retirement, he is going to retire within.
Just say what it.
Twenty 24. All 6, 25, 6, and 13.
Retirement, what does the guideline say?
25, 6, 18. ಇದೆಲ್ಲ ಸಿ ಎಲ್ಲ ಎಫ್ ಇದೆ. ಬೇಡ ಇನ್ನೊಂದಿದೆ. ಇದೆ ಇನ್ನೊಂದು ದಟ್ ಈಸ್ ಡಿಫರೆಂಟ್ ಗೈಡ್ಲೈನ್ 1/12/24 ಒಂದಿದೆ. ಸರ್ಕಾರಿ ನೌಕರ ಅವಲಂಬಿತ ಮಕ್ಕಳು ಪತಿ ಪತ್ನಿ ತಂದೆ ತಾಯಿರುಗಳು ತೀವ್ರತರವಾದ ಅಂಗವೈಕಲ್ಯವನ್ನು ಹೊಂದಿದಲ್ಲಿ ಹಾಗೂ ಸರ್ಕಾರಿ ನೌಕರನ ಅವನ ನಿರ್ವಹಣೆ ಹಾಗೂ ಪುನರ್ವಸತಿಯ ಜವಾಬ್ದಾರಿ ಹೊತ್ತು ಅಂಗವೈಕಲ್ಯರ ಹಕ್ಕುಗಳನ್ನು ಸಂರಕ್ಷಣೆ ಮಾಡುವಲ್ಲಿ ಹೆಚ್ಚಿನ ಪಾತ್ರ ವಹಿಸಿದಲ್ಲಿ ಅಂತ ನೌಕರಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುವ ಷರತ್ತುಗೊಳಪಟ್ಟು ಅಂತ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ವೇತಕಾಲಿಕ ವರ್ಗಾವಣೆಯಿಂದ ವಿನಾಯಿತಿ ನೀಡಬಹುದು.
Correct, but to show that the mother is blind.
Yes, I have already produced that
Yeah.
medical certificate.
ಅದ್ ಕೊಡಿ ಆ guideline ಕೊಡಿ.
ಅದು ಇನ್ನೊಂದಿದೆ, just I'll produce that. I'll take the printout. Some English version is there, detail 24, that is 25/6/20. Yes. I'm sorry, ಅದು ಏನು by mistake ಇನ್ನೊಂದು ಫೈಲ್ ನಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. ಇದಿದೆ ಕನ್ನಡ ಇನ್ನೊಂದಿದೆ ಗೈಡ್ಲೈನ್ಸ್ 12/6.
Page print out ತೆಗೀರಿ.
A5 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ.
A5
Yes, my lord.
Page
36. ಅದು ಅಂಗವೈ ಅದು ಇಂಕ್ ಪೇಜ್ 40 ಅಲ್ಲಿ ಡಿಸಬಿಲಿಟಿ ಇದೆ. 40 ಇಂಕ್ ಪೇಜ್ 40 40 ರೈಟ್ ಸೈಡ್ ನಲ್ಲಿ 6, 7 ಇದೆ. I am light of the above so and so overall permanent physical impairment as per the specified guidelines is as follows in figures 100% inwards so and so.
He's blind, is it?
Yes, my lord, blind.
ಅದ್ ಕೊಡಿ ಆ guideline.
Usual result.
ಇದು ಮೊಬೈಲ್ ಅಲ್ಲೇ ಕೊಡಿ ನೋಡಿ.
Mobile ಕೊಡಿ.
ಯಾವ್ದು ಬೇಡ. Will stay the impugned order but allow the proceedings before the KT on merits to proceed.
Please.
ಅದ್ ಮೇಡಮ್ ಕೇಸ್ ನಿಮ್ದಿನ್ನೂ ಬಂದಿಲ್ಲ. The petitioner. That's called in question correctness of the order passed by the tribunal. Whereby the tribunal has page, tribunal order page.
Tribunal order.
Issued notice
Only issued notice.
without considering the prayer
43.
for
43.
interim stay of the order of transfer at annexure A3.
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 Yes.
A3 serial number 63. Insofar as 63.
At the serial number
63.
63. Is the case of learned counsel for the petitioner that her mother, his mother who is staying with him suffers from disability of 100% as evidenced by document at annexure A5. And in such circumstance, the authority ought to have considered relaxing the applicability of transfer guidelines.
Please.
In light of the amendment to the transfer guidelines. That's put in.
Yes, ma'am.
So and so. Now, in terms of that, they have the power to relax. Huh?
Yes, my lord.
They have the power to relax.
Relax.
But have you represented to them?
Like they can't transfer, and that is the guidelines.
Vinayati anta.
Vinayati anti.
ಅಲ್ಲ ಅದು ಕನ್ಸಿಡರ್ ಅಂತನಾ ಅಥವಾ ವಿನಾಯಿತಿ ಅಂತ?
Vinayati. C ಅಂತಿದೆ C ನ D ಲಾಸ್ಟ್.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ?
Vinayati ಅಂತಿದೆ. ನಮ್ಮ ಆಫೀಸ್ನಾಗ ಎಷ್ಟು ಚಂದ ಹುಡುಕ್ತಾರೆ.
In light of GO number so and so. GO number so and so. Taking note of the said contention, there would be stay of the order at annexure A3. Will be clarified that matter may be proceeded with on merits by the tribunal.
In so far as petition.
Interim order is granted, taking note of contention that the dependence that the petitioner's mother being fully dependent on the petitioner and would find it difficult to relocate herself to the new place. And accordingly, tribunal may ought to have referred to such contention while not passing any order on the interim relief sought for. AG is directed to accept notice for respondents 1 to 3
Directly.
and 5. What about 4?
4 notice has to come.
Issue notice to R4. But R4 is not necessary.
Not necessary, but our that.
No, then you are adding to their delete R.
Yes, ma'am. With the
R4
permission of the court.
R4 is deleted. Right of no file. R4 is not necessary.
Yeah, this
Not
is
that you are put on deputation in
ma'am.
that institution. Correct?
Yes, ma'am.
Next.
ಕೊಡ್ತೀನಿ ಟೈಪ್ ಮಾಡಿಸಿ ಟೈಪ್ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಸರ್ ಟೈಪ್ ಮಾಡಿಸ್ತೀನಿ
C, class C. No, but have you represented what the rule says? The rule says that in case the mother is disabled, etc., ಸಂಬಂಧಿತ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುವ ಷರತ್ತಿಗೊಳಪಟ್ಟು ಅಂತ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಯತಕಾಲಿಕ ವರ್ಗಾವಣೆಯಿಂದ ವಿನಾಯಿತಿ ನೀಡಬಹುದು.
completion that entire that guidelines is there. As well correct fully there they are if they are going to retire or if they are independent or so and so medical.
ಪೇರೆಂಟ್ಸ್ ಆದ್ರೆ ವಿನಾಯಿತಿ ಅಲ್ಲ, ವಿನಾಯಿತಿ ನೀಡಬಹುದು. ಪೇರೆಂಟ್ಸ್ ಅಥವಾ ಡಿಪೆಂಡೆಂಟ್ ಯಾರಾದ್ರೂ ವಿನಾಯಿತಿ ನೀಡಬಹುದು ಅಥವಾ ಹತ್ತಿರದ ಸ್ಥಳಕ್ಕೆ ನಿಯುಕ್ತಿಗೊಳಿಸಬಹುದು.
ನಂದು ನಿಯುಕ್ತಿನೇ ಅಲ್ಲ, that is only transfer.
ಬಟ್ ವಿನಾಯಿತಿ
transfer
ನೀಡಬಹುದು.
ಅಲ್ಲ transfer ನಲ್ಲಿ if they going to retire within 2 years they can't transfer. At the back end of his service they can't. That is service the guidelines for the transfer.
But if you complete your tenure, then
Some tenure.
suppose
Sir, even though you completed tenure, there is no money, there is no provision to transfer. If he is going to retire, I'll furnish money. I'll bring that.
yes, next.
ವಾಸುದೇವನ್ ಕೇಸ್
Yes,
Number 60, Prashant Vajan.
yes,
Blood, the petitioners are working as a senior specialists in the Health and Family Welfare Service Department, my lord.
yes,
Blood, in 2007, my lord, all these, the research institutes have been established, including the Bidar Medical Institute of Science. Blood, the district hospitals attached to were, which were with the, under the control of the health department were, my lord, entire hospital along with the infrastructure and staff were transferred to the Bidar Medical Institute of Science, my lord. But thereafter, my lord, the petitioners who were working in the health department were deputed to the 4th respondent institution as specialist and senior specialist, my lord, by orders dated, my lord, 12/10/2023, annexure A1, my lord. Lordship will get at page 31, my lord, the name of the first petitioner, serial number 16. Lordship got it, ma'am. Dr. Lokesh.
yes,
But he was transferred to district hospital, Bidar, that was under the control of the 4th respondent institution, my lord. After the transfer of the district hospital to Bidar, my lord, it became part of the Bidar Institute. Therefore, my lord, the petitioner is sent on deputation to work in the district hospital at Bidar, which was under the control of, my lord, the BIMS. Similar is the case in respect of second petitioner, my lord, at page 33. by notification dated 24/8/2023. My lord, kindly see, my lord, ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ವರ್ಗಾವಣೆ ನಿಯೋಜಿಸಿ ಆದೇಶಿಸಿದೆ. My lord, the name of the second petitioner is at serial number 32.
Serial number
32, man. Lord, the contention of the petitioner, my lord, before the tribunal is that it is a deputation under Rule 50 of KCSR.
No, just 1 minute, just one. Now, in so far as this second petitioner,
Yes, ma'am. Serial number 32, my lord, page 35.
correct, but she is only transferred, not deputed.
No, my lord, it is a deputation for this reason. My lord, the district hospital is under the control of the fourth respondent institution after it was transferred to the institute permanently, my lord.
So it's now transferred to BIMS.
Deputed to BIMS.
No, what I'm saying, the district hospital.
Yes, it is permanently transferred to fourth respondent BIMS. Therefore, my lord, any posting from health department is on deputation only.
So it's not done, so government doesn't have direct control.
No.
It is done through the dean and director, Bangalore.
Done through the medical education department. My lord, it has to be deputed to the medical education deputed, posted to BIMS. Because the fourth respondent is under the control of medical education department.
Yes.
Now, my lord, by these two orders, we were sent on deputation. Now, my lord, the deputation is governed by Rule 50 of KCSR. My lord, I may be permitted to read Rule 50 for a moment, my lord. Your lordship may kindly take Rule 50 of KCSR, my lord.
Rule 50.
Rule 50, my lord.
Ah.
My lord, when a government servant is permanently transferred or deputed from one department to another, under the provision of Rule 16 of the KCSR, General Recruitment Rules 1977, he will drop a new post at the same stage in which he was drawing in the old post and earn the next increment on the date on which he would have earned it had he continued in the old post. But this is not relevant, my lord. Your lordship may kindly come to sub-rule 3, my lord. Such deputation should not ordinarily extend beyond 5 years except under the special orders of the government. Lordship, correct.
But that is the outer limit.
Yes, my lord. Now, to fix the minimum limit, my lord, a government order has been issued. That I produced at page 54. Page 54, my lord. Para 2 is relevant, my lord. I'll read from para 2, my lord.
Yes.
May I read, my lord?
Yes.
ಈ ರೀತಿ ಸ್ಪಷ್ಟ ನಿಯಮಗಳಿದ್ದರೂ ಕೂಡ 5 ವರ್ಷಗಳ ನಿರಂತರ ಎರವಲು ಸೇವೆಯನ್ನು ಅವಧಿ
just
54, my lord, annexure A2.
A2 na.
A2, 53, page number 53.
My lord, I have typed copy, I have produced.
53.
Yes.
Page 53.
Odi.
My lord, second paragraph, my lord. ಈ ರೀತಿ ಸ್ಪಷ್ಟ ನಿಯಮಗಳಿದ್ದರೂ ಕೂಡ 5 ವರ್ಷಗಳ ನಿರಂತರ ಎರವಲು ಸೇವೆ ಅವಧಿಯನ್ನು ವಿಸ್ತರಿಸಲು ಶಿಫಾರಸುಗಳೊಡನೆ ಅನೇಕ ಪ್ರಸ್ತಾವನೆಗಳು ಬರುವುದನ್ನು ಗಮನಿಸಿ ಸರ್ಕಾರವು ಈ ವಿಷಯವನ್ನು ಪುನಃ ಪರಿಶೀಲಿಸಿ ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲೂ ಏನೇ ವಿಶೇಷ ಕಾರಣಗಳಿದ್ದರೂ ಸರ್ಕಾರಿ ನೌಕರರ ಎರವಲು ಸೇವೆ ಅಥವಾ ವಿದೇಶ ಸೇವೆಯಲ್ಲಿ 5 ವರ್ಷಗಳಿಗೆ ಮೀರಿ ಮುಂದುವರಿಸಲಾಗುವುದೆಂದು ನಿರ್ಣಯ ಈ ಕೆಳಗೆ ಸೂಚನೆಗಳನ್ನು ತಂದಿದೆ. 1. ಸರ್ಕಾರಿ ನೌಕರರು ಎರವಲು ಸೇವೆಯು ಪ್ರಾರಂಭದ 3 ವರ್ಷಗಳ ಸಾಮಾನ್ಯ ಅವಧಿ ಮತ್ತು ಗರಿಷ್ಠ 5 ವರ್ಷ ಸೀಮಿತವಾಗಿರಬೇಕು. ಸೊ ಮಿನಿಮಮ್ ಇಸ್ ಫಿಕ್ಸ್ಡ್ ಆಸ್ 3 years. by this circular.
So,
My lord,
uh,
placing reliance on this, reliance on this circular, my lord, I had approached the honorable tribunal. My lord, the honorable court initially, my lord, granted an interim order, my lord, which I have produced at page 94, my lord. My lord, it starts at page annexure A7, my lord, page 90, my lord. Pagination, I'm sorry about the pagination, my lord. Annexure A7, my lord. This is the order in interim order in application 208 to 2018, my lord.
yes,
My lord, your lordship may kindly come to page, the order portion, my lord, at page 95, if I am right, my lord.
Yes, 94, my lord.
okay.
94, my lord.
Yes,
My lord, we heard the learned counsel for the applicants on the interim prayer of stay of the impugned order under annexure A8. It is submitted by the learned counsel for the applicants that the minimum period that is prescribed is not completed by any one of the applicants herein. We peruse the pleadings and also the documents produced by the applicants. So also consider the oral submission made by the learned counsel for the applicants. After perusal of the entire material, the impugned order dated 21/1/2025 passed by the first respondent produced at annexure A8 insofar as the applicant herein are concerned is stayed till next date of hearing. But this order was granted in the connected applications. This was also produced along with the application before the tribunal, which went before another bench. Now, my lord, the another bench has refused to grant an interim order stating that your deputation period is only 1 year and therefore you are completed and you cannot continue.
no, just 1 minute. Now, this same order is challenged.
Same order is challenged. Very same order. My lord, in this impugned order, my lord, the petitioner therein, the applicants therein are at page 50, my lord, page 51, my lord.
Even 1/2025.
Yes, my lord, same order. 21/1/25 is the one which is under challenge, even here also.
My lord, I
But,
produced the memo, my lord.
but now the position is clear,
Yes,
notwithstanding arguments made in my previous roster,
please, ma'am.
wherein when I refused to give stay for repatriation beyond 5 years, all of you protested.
No, my
Many
lord.
matters, no. That 5 years, no, 5 years is the limit.
5 years, yes, but not, this is the 5 years, it is less than 5 years, my lord.
No, that is correct. But what I'm saying, you have to accept, so beyond 5 years, you shouldn't protest.
Yes, ma'am. Beyond 5 years, my lord, the rule also says beyond 5 years, except under special orders of the government, as per the rule. If there is a special order, my lord, they can be extended beyond 5 years also.
The counsel appearing for the petitioners submits that the order at annexure,
My lord, the honorable tribunal's order, my lord,
no, order of
A5, my lord, annexure A5, page 69.
the order at annexure A5, by virtue of the order of annexure A5, they have been repatriated. Full stop. It is submitted that insofar as petitioner number 1.
Yes, ma'am.
The petitioner number 1 was posted on?
On, my lord, 12/10/2023, my lord.
12/10/2023 on deputation.
Yes, ma'am.
And the minimum period of deputation in terms of the circular at annexure.
My lord, annexure page 54, my lord. Annexure A2, my lord.
At annexure A2 has not been taken note of. Full stop. Insofar as petitioner number 2 is concerned, he said that the said petitioner was posted on
26/8/23.
26/8/23, and similarly, the order of repatriation is within the minimum period of 3 years as which ought to have been protected in terms of the circular at annexure A2.
Yes.
They submitted that the other officers who were a part of the order of repatriation impugned herein at annexure A5 had
Yes.
approached the tribunal in application 222 dash
208. Lord, there are several orders, my lord. One of them is 208.
220 to 232 of 2025.
Yes, ma'am.
Interim order was passed with respect to such of the employees. While taking note of the circular at annexure A2.
A2, ma'am.
Annexure A2. Accordingly, on the ground of parity, noticing that the petitioners herein were identically placed as those employees in application 220-223 with respect to whom interim order has been granted. In the present case also, there would be stay of annexure A5.
A5,
and so
madam.
the petitioners are concerned till the next date. He is directed to accept notice for respondents 1, 2, and 3.
In A5, one of the petitioner is 92.
And another is 65, ma'am.
And 4 dean and director. Who
Yes.
appears?
Dean and director, a notice has to be ordered, ma'am.
Emergent notice to, oh, it's made clear that the proceedings before the KAT could proceed.
Please.
That date is 24/8, my lord, not 26/8 anta bandide. 24/8 insofar as the second petitioner.
24/8.
And
All right, may be permitted to take hand delivery, ma'am.
Upload aಗುತ್ತೆ. We'll
Please.
have it uploaded
Please, ma'am.
because the other branches will have to wait. I'll have it
Please.
uploaded.
Please.
Please.
my lord, on submission, insofar as that habeas corpus, I required the order of this honorable court, my lord. Advisory board ಗೆ ಅದು ಕಾಪಿ ಕಳ್ಸಕ್ಕೆ ಅದು ಸಿಕ್ಕಿಲ್ಲ, ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ. ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಲೆಟರ್ ಬರಿಬೇಕು. ಇವತ್ತು ಮಧ್ಯಾಹ್ನವರೆಗೂ ನೋಡಿದೆ, ಮಧ್ಯಾಹ್ನವರೆಗೂ ಆಗಿಲ್ಲ, ಅದಕ್ಕೆ ಐ ಆಮ್ ಸಬ್ಮಿಟಿಂಗ್.
I was not there in town.
Please, madam.
I will just check.
Please, madam.
Serial number 29, my lord. It may post on Friday. I will argue on the final hearing there. Friday.
Bench, there's some alteration for this week, so we'll have it next.
Sir, my lord.
Serial number
Sir.
39, date next week.
Okay, told.
Serial number 42, my lord. Final hearing ಇದೆ. Just a minute.
Next week date ಕೊಟ್ಟು.
ಗೈಡ್ಲೈನ್ಸ್ ಇದಾವಲ್ಲ. ತರಕ್ ಹೋಗಿದೆ ಗೈಡ್ಲೈನ್ಸ್. ಸರ್ ಒಂದು ಪೇಪರ್ ಕೊಡಿ ಸರ್. ಸರ್ ಒಂದು ವೈಟ್ ಪೇಪರ್ ಕೊಡಿ ಸರ್. ಒಂದು ಪೇಪರ್ ಕೊಟ್ಬಿಡಿ ಸರ್, ಮೆಮೊ ಒಂದು ಪೇಪರ್ ಕೊಟ್ಟು ಮೆಮೊ ಕೊಡ್ತೇನೆ. ಅದನ್ನ ತರಕ್ ಹೋಗಿದ್ದೆ, ಗೈಡ್ಲೈನ್ಸ್ ತರಕ್ ಹೋಗಿದ್ದೆ. ಸಿಕ್ತಿ ಕೊಡ್ತೇನೆ, ಗೈಡ್ಲೈನ್ಸ್ ಸಿಕ್ತಿ. ಹಾ ಕೊಡ್ತೀನಿ, ಅದಕ್ಕೆ ನಾನು ತರಕ್ ಓಡೋಗಿದ್ದೇನೆ.
ರೆಡಿ ಇಟ್ಬಿಡಂತ ಸರ್ ನಿಮ್ದು ಡೇಟ್ ಬೇಕಾ ಸರ್?
ಯಾಕಂದ್ರೆ 3 ದಿವಸ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇರ್ತಾರಂತೆ, ಅದಕ್ಕೆ ಆಫ್ಟರ್ ಸಾಹೇಬ್ರು ಎಂದಿರ್ತಾರೆ ಅವತ್ತ. ಯಾಕಂದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅದ ಮುಗಿಸ್ಬೇಕಾಗಿತ್ತು ನಮ್ಗೆ, ಓಲ್ಡ್ ಏಜ್ ಪರ್ಸನ್ಸ್.